I beg pardon. The petition is convicted for 10 years. In the meantime, custody for 8 years. But the last occasion, the case was listed on 29/2022. In the meantime, not listed. Give it.
It's a bit tied up materials.
SC Act appeal mail.
My lord, CRL number 891 of 2023, fresh matter.
Admission matter.
Yes.
My lord, one tied up matter and another matter under SC state bill.
Give it.
Beg pardon, Your Lordship. I'm mentioning two matters, Your Lordship. CRLA number 831 of 2023, criminal revision number 401 of 2023. Both are in the nature of bail, Your Lordship.
Okay.
Grateful, ma'am.
Put it down. It will come next week.
Grateful, Your Lordship.
May pardon mention, my lord. Weekly list item number 19, my lord. Weekly list item number 19, my lord.
19.
Yes, my lord.
Yes. What do you want?
Paperwork is not received, my lord.
No, the paperwork is here. You get the paperwork and get ready.
Office रे नहीं मना कले extra copy नहीं कले court रे.
Have you got the power in this case?
No, my lord. On behalf of Manoj Vihari Das.
Ask Mr. Das to come and receive the paperwork. It is available here. Okay? Yeah.
Weekly list item number 1. May I please, Your Lordship? But, in this case, my lords, before I place the exact findings, my lord, I crave Your Lordship permission, my lord, to place 10 lines, my lord. The complainant in this case was the leader of the village committee, my lords. And secondly, my lord, he was entrusted by the BDO Tikavali, my lord, to construct the building of the Anganwadi centers at Birangi, my lords.
Yes,
And
Mr.
after
Sarangi.
completion of that building,
I am ready. No, please take your seat. After he finishes, you will. I have already submitted the other day. No, it's all right. Just, yes. Yes.
lords, the complainant was the village committee leader, and he was entrusted by the BDO Tikavali, my lord.
Why don't
To
you read
construct-
the FIR?
My lords, I crave Your Lordship permission, my lord, to place 5 lines, my lord, thereafter. my lord.
First read the FIR. Let me know
Ma-
the.
Page 25. Mostly Damodas Pradhan, Ravi Pradhan.
Vyasudev Pradhan is PW?
The complaint is PW 5 minutes,
Okay.
and the accompanying witness is PW 2 minutes.
This one, so, Adhinare Avastita, yes. Read out. Amo Gramo, Birangi Tikapali block Adhinare Avastita. এবং মতে উক্ত গ্রামর
94-95 ପାଇଁ ସର୍ବସମ୍ମତି କ୍ରମେ କରାଯାଇଥିଲା। ଗତ 94-95 ମସିହାରେ ଆମ ଗ୍ରାମର ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ର ଗୃହ ନିର୍ମାଣ ପାଇଁ 65,000 ଟଙ୍କାର ଅଟକଳ ମଞ୍ଜୁରୀ ହୋଇଥିଲା ଏବଂ ଟିକାବାଲି ବିଡିଓ ମତେ ଉକ୍ତ କମିଟି ସମ୍ପାଦନ କରିବା ପାଇଁ ଆଦେଶ ପ୍ରଦାନ କରିଥିଲେ। ମୁଁ ଉକ୍ତ କାମର ମୂଳଦୁଆ କାମ ଡିସେମ୍ବର 94 ସୁଦ୍ଧା କରି ପ୍ରଥମ ବିଲ୍ 18,700 ମାତ୍ର ଟଙ୍କା ପାଇଥିଲି। 1995 ମସିହାରେ ଉକ୍ତ କାମର ରୁଫ୍ ଲେଭେଲ ପର୍ଯ୍ୟନ୍ତ କାମ ପରେ ଦ୍ୱିତୀୟ ବିଲ୍ 13,300 ଟଙ୍କା ମାତ୍ର ପାଇଥିଲି। ମୁଁ ଆଡ଼କୁ ପ୍ରାୟ 7 ମାସ ହବ ଉକ୍ତ କାମର ଚୂନ ଓ ରଙ୍ଗ ଦିଆ କାମ ଛଡ଼ା ସବୁ କାମ କରିସାରି ଅଛୁ ଓ ଓଭରସିଅର ଶ୍ରୀ ପ୍ରମୋଦ କୁମାର ପଣ୍ଡା ଉକ୍ତ କାମର ପେମେଣ୍ଟ କରି ବିଲ୍ ଟଙ୍କା ଦେବା ପାଇଁ ଅନୁରୋଧ କରି ଆସୁଛନ୍ତି। ବର୍ତ୍ତମାନ କୁଲିମ୍ୟାନ ତାଙ୍କର ମଜୁରୀ ଟଙ୍କା ପାଇବା ପାଇଁ ବାଧ୍ୟ କରିଥିବାରୁ ମୁଁ ଆଡ଼କୁ ପ୍ରାୟ 8 ଦିନ ତଳେ ଓଭରସିଅର ଶ୍ରୀ ପଣ୍ଡା ବାବୁଙ୍କୁ ଅନୁରୋଧ କରି କହିଲି ଯେ ଉକ୍ତ କାମର ପେମେଣ୍ଟ କରି ବିଲ୍ ଦେଲେ
Please adjust the mic properly. Yes. Yes.
ମୁଁ ଉକ୍ତ କାମ ଆମେ କ୍ଲିୟର
Yes.
ଉକ୍ତ କାମର ପେମେଣ୍ଟ କରି ବିଲ୍ ଦେଲେ ମୁଁ କୁଲି ମାନଙ୍କୁ ପଇସା ପଇଠ ଦେବି ଏବଂ ବଳକା କାମ ସମ୍ପୂର୍ଣ୍ଣ କରିବି। କିନ୍ତୁ ପେମେଣ୍ଟ କରିବା ପାଇଁ ଓଭରସିୟର ପଣ୍ଡା ବାବୁ 5,000 ଟଙ୍କା ଲାଞ୍ଚ ଦେଲେ। ମୁଁ ତାଙ୍କୁ ଅନୁରୋଧ କରି କହିଲି ମୁଁ ଗରିବ ହେତୁ ଏତେ ଟଙ୍କା ଦେଇପାରିବି ନାହିଁ ଏବଂ ବହୁତ ଅନୁରୋଧ କରିବା ପରେ ସେ କହିଲେ 2,000 ଟଙ୍କା ନଦେଲେ ପେମେଣ୍ଟ କରିବି ନାହିଁ। ମୁଁ ବହୁତ ଅନୁରୋଧ କରିବା ପରେ ସେ କହିଲେ ପ୍ରଥମେ
2,000 ଟଙ୍କା ନଦେଲେ ମେଜରମେଣ୍ଟ କରିବି ନାହିଁ।
ମେଜରମେଣ୍ଟ କରିବି ନାହିଁ। ଆଉ ମୁଁ ବହୁତ ଅନୁରୋଧ କରିବା ପରେ ସେ କହିଲେ ପ୍ରଥମେ 1,000 ଟଙ୍କା ଦେଲେ ସେ ମେଜରମେଣ୍ଟ କରିବାକୁ ଯିବି ଆଉ ବଳକା ଟଙ୍କା ମତେ ପେମେଣ୍ଟ ପରେ ଦେବେ।
ମେଜରମେଣ୍ଟ ପରେ
ଦେବେ ନହେଲେ ମେଜରମେଣ୍ଟ କରିବି ନାହିଁ କି ବିଲ୍ କରିଦେବି ନାହିଁ। ମୁଁ ତାଙ୍କ କଥାରେ ବାଧ୍ୟ ହୋଇ ରାଜି ହେଲି। ମୁଁ ବହୁ କଷ୍ଟରେ 1,000 ଟଙ୍କା ଯୋଗାଡ଼ କରି ମୋର ଇଚ୍ଛା ବିରୁଦ୍ଧରେ ବାଧ୍ୟ ହୋଇ ଉକ୍ତ ଲାଞ୍ଚ ଟଙ୍କା ଓଭରସିୟର ପ୍ରମାଣକୁ ଆସନ୍ତାକାଲି ଦେବାକୁ ଜଣାଇଛି। Now the essence is that there was a construction work and the complainant was entrusted by the BDO Tikavali to build that Anganwadi center at Birangi. And after completion, he approached the complainant and who was junior engineer on the block. He is to take measurement and to pay the
not complainant, the accused.
Accused a junior engineer of that block. The accused engineer demanded 5,000 rupees to take the measurement and subsequently agreed to 2,000, 1,000 prior to final measurement and rest 1,000 prior to passing of the bill. And there was a successful trap and the accused was caught red-handed.
What about the evidence of the
evidence of PW5 is a decoy and attesting witness is a PW2 as page 36.
They supported the prosecution case.
They didn't
come to the
evidence
of PW5.
PW5 is page 47.
Come, read out.
I am the complainant in this case. I know the accused standing in the dock. He is JE in the Tikavali block. I was doing contractory work under the block 94-95. I took work worth 65,000. For my work, I got some payments, and for the dues, I approached the JE, who told me to look after my matter by the assistant engineer. A report was lodged before the vigilance officer. The vigilance officer drafted a report. I copied out the same. This is that report, but it was not written with my own consent. This is the fact marked as Exhibit 7, and my signature thereon is marked as Exhibit 7.
So he didn't support the prosecution.
He resigned. And thereafter, he was declared. Thereafter, the examination has continued. Then, Lords, you can turn to the next eyewitness, that is the shadow witness at page 39 of the Lordship paper B.
No, just in the
should I proceed?
The cross-examination by the prosecution.
Yes.
PW5, read it out. Paragraph 2.
Paragraph 2.
This is the same page which you are reading.
No, Lord,
PW5.
It is a fact that the work order, paragraph 2. It is a fact that the work order was issued by BDO Tikavali and I was paid 87 towards the foundation work. In the second occasion, I received rupees 13,300 towards cost of work of the roof level. It is written in my report that I approached several times to the accused for the doing measurement of my work for getting my payment. But all were written as per the instructions of the inspector of the vigilance. It is not mentioned in the report that the accused demanded rupees 5,000 bribe from me. I didn't mention in the report that the accused told unless rupees 2,000 is paid in order to do the work. It is not mentioned in the report that the accused told to pay 1,000 lastly. Otherwise, the accused would not go to worksite for a measurement. It is not a fact that for which I lost the report before the vigilance officer. It is a fact that I started. I stated earlier before the IO that for the trap we had been to Tikavali. I stated that from there we had been to Bhanjanagar Revenue IV, and some officials also reached there. It is not a fact that I stated.
Okay, Mr. Ajit appears is totally hostile, even in cross-examination. All right, now we come to the cross-examination by defense.
Para 3 months?
Yes.
Yes. The allotment and disbursement of the money concerning the work is done under the supervision of the BDO. The BDO himself passes the final bill. After completion of our work, we used to inform the BDO, who gives instruction to the concerned chief or officer for making necessary measurement. Whoever sent by the BDO to do the measurement used to come. After measurement, the bill is prepared by the accountant and the same is prepared. I was called by the vigilance officer and asked to sit in a room. They prepared some document and asked me to put my signature on different documents. I was called by them to accompany them to Tikavali. Taliguda. At the place of detention, after arrival of the vigilance officer, they got all the hands of the accused, and I do not know what else happened. Page 50. Except signing on some documents, I didn't give my statements before the vigilance officer as suggested to me during my my examination in chief.
Okay, so total.
This is all about
now
that.
You come to the overhearing witness.
Yes, page 39 of the law.
Who is that overhearing witness?
Well, that's Rajinikanth.
No, PW.
PW, 2 minutes. PW2, page 39.
Okay, read it.
On 5/6, did your lordship get that page 39? On 5/6/96, I was attached to a Tahsil office, Bhanjanagar. On that day, the sub-collector instructed me to go to IV to meet vigilance staff. Kalicharan Satpathy and Birupakya Panda had also went there as per the instructions. There, the vigilance staff, Bhanjanagar Tahsildar, the official witnesses and complainant, Varsadev Pradhan, were present. He was introduced to all of us. The complainant explained that he was to get some money towards his bills, and he told that the accused J told him to pay some money for getting the dues. There are 1,000 rupees notes amounting rupees 1,000. I do not know anything else in this case. At this stage, the additional PP prays to.
He also did not.
He also
support the prosecution case.
Yes.
Oh.
And if you should turn to the next page, page 40. I was not examined by the IO. It is not a fact. I was examined by the IO and stated before the IO as follows. So, in entirety of that particular, he declined. He didn't accept.
Totally hostile.
Correct. Yeah, no. Lordship may
come to the then cross-examination.
Paragraph 3, page 41. At the signing, preparation and retention of report, I didn't make any endorsement that after knowing the contents of the report, I signed the reports. So also, I didn't make any similar endorsement on seizure list on which I signed. The preparation report and detention report were also not read over and explained to me. I merely put my signatures on different documents as required and instructed by the vigilance officers. My lords, in this situation,
now let us stop here. When these two vital witnesses, in a case of this nature, these two witnesses used to be vital witnesses. At least they highlight about the demand and demand and acceptance part. They used to mainly tell. So far as recovery is concerned,
TLO.
That is TLO and sometimes. So now, when all the three things are necessary to find a person guilty, and two of the vital witnesses have totally not supported the prosecution case, that is the decoy as well as the shadow witness or overhearing witness, then these two important aspect like demand and acceptance cannot be said to have been proved. Once these two goes, suppose you prove through the other witnesses about the recovery part, that would not be sufficient. Then how can you challenge the order of acquittal?
Let's before I answer I place the main submission, my lord. In this case, I understand my predicaments, and in fact, particularly when both the eyewitnesses, my lord, decoy and shadow witness didn't support the prosecution, my lords. My lord, there was a successful trap was laid. Well, they subsequently
Successful trap means recovery part is there.
yes, no tented Jesse note was recovered
Right,
from
right,
the start.
from
Okay. And my lords, your lordship may put me a question: what are the grounds for which the acquittal they were let off? There are two grounds, my lords. At page 21, my lord, absence of prior demands. 2, absence of demand during trial. Your lordship turn to page 21 of the paper book. The two grounds for which they were let off.
No, let us come to the accused statement.
Yes, please.
Accused statement, welcome. Come to the last question, that is question number 24. Not last exactly,
in this paper, in this
paper page number 33, or it is perhaps running page is
yes,
55.
I got it. Lords.
Come to question number.
Do you want to say anything else?
Right, that part.
ମୁଁ ଅଫିସରେ ଥିବା ବେଳେ 5-6 ଜଣ ଲୋକ ମୋ
ଅଫିସ କୁ
ପଶି ଆସି ମୋ ହାତ ଧରି ପକେଇଲେ। ଜଣେ ମୋ ପକେଟରେ ଟଙ୍କା ଭର୍ତ୍ତି କରିଦେଲେ, ତାପରେ ମତେ ଟଙ୍କା ବାହାର କରିବାକୁ କହିଲେ।
Okay. Yes.
I'm placing the second line of the page 21. Applying the principle laid down in this reported case to the facts of the present case, I am also inclined to say that in the absence of any evidence to prove the prior demand or acceptance of bribe of demand at the time of alleged trap, mere recovery of money as stated by PW4, the Vigilance Constable PW6 Tahsildar is not sufficient to bring on the charges under Section 13(1)D, read Section 13(2)(7) of the Prevention Corruption Act. So, absence of prior demands and access to demand on the date of trap was there. For two reasons, my lords, the order acquittal, the input order acquittal was passed. Now, my lords, in this particular situation, when the decoy, the main witness on which the prosecution rely on his statements below, in the absence of if the decoy becomes hostile, what is the alternative submission available for a state, the prosecution to proceed, my lord. On that issue, a particular point of law was referred to the Honorable Supreme Court, a 5-judge bench judgment. The point of law referred, lords, was whether the issue before the 5-judge bench was whether in the absence of evidence of the complainant, direct or primary evidence of demand of illegal gratification, is it permissible to draw an inference, deduction of culpability, guilt of the public servant under Section 7 and 13(1)D, read with Section 13(2) based on the evidence adduced by the prosecution?
That decision also doesn't say about not only demand, here also acceptance. There is no evidence. That you say, I know that at the 5, what is that decision refer to?
2023 volume 4. Niraja Datta.
Niraj?
N-W-E-R-A-J.
A-N?
N-W-E-R-A-J. Niraj.
Niraj.
Datta. D-U-T-T-A.
Niraj Datta versus?
Versus state, bracket starts, government of NCT of Delhi, bracket name.
Reference kaile?
2023 volume 4 SCC 731.
That says about that demand if it can be otherwise also inferred once there is evidence about the clinching evidence about the acceptance recovery, then that part, even though there is no direct evidence or the complainant turns hostile, that's a different matter. But here is a case as you have found out that not only pre-demand or on the date of draft, that demand part is missing, acceptance part is also missing. Only part which is available as per the evidence of two official witness is the recovery. So that decision pursued not be sufficient to hold that anything wrong has been caught. The scope of interference is that there is
Even if there is no statements with regard to the decoy regarding the demand and all these things,
that can be done.
but if the acceptance
Right.
by the accused, knowing consciously this is not legal remuneration, but
Absolutely.
illegal gratification,
Right.
that also that apprehension can be inferred.
Right. So here
And
is
a lordship permits me, Lord, may place the two lines
you can-
answering this particular
what
issue.
is that paragraph you are referring to?
This question
Question is posed that
from
is
and paragraph 20.
question.
Sorry, para 90.
No. Question formulated in which paragraph?
Para 90.
Para 90.
90.
Okay, and answered in para?
Answer in 87. 1 minute. Para 89.
How can it be?
It starts from 88.
When the question is formulated in paragraph 90, how can the answer would come prior to that? Tell me which paragraph the question has been formulated.
No,
That
sir.
whether in such a situation the conviction can be sustained or not.
Accordingly, the question referred for consideration.
Paragraph ta kuhuntu
Para 90. But this is in my copy. Your lordship is correct, my lord.
Just a minute.
Ask the question, then the answer.
बाहर एटा ये पहिले कोन बाहर कोन तमे एससीसी ऑनलाइन है से काई बसछो तमे जस्ट अ मिनट type it out. This 2023, 2004. Yes. SCC page number is 731. Control her. $71. Okay, I got this. Please go. So, where you said that the question has been formulated?
In fact, in the copy I'm holding, Miller's para 90.
Are you holding that SCC exact or it is from?
Yes.
Okay. Which paragraph you said?
In fact, if lordship turn to page 734, lords.
734. Okay, just a minute.
The last paragraph above the citation.
No,
it starts from accordingly.
You are referring to head note. You come to the paragraph.
There, I got it, page 19, para 90.
Para 19. Oh, 19, if you say that, it's all right. 19, it starts from
Your
paragraph
Lordship is correct,
19.
Lord. The question
in-
should be on the first
in
paragraph,
P.
subsequently the answer.
Satyanarayan Murthy. Let us-
Above that, accordingly, the question referred for consideration of this five-judge bench is answered as under. In the absence of evidence of the complainant direct, primarily oral, documentary evidence, it is permissible to draw an inference, deduction of culpability, guilt of the public servant under section 7 and section 13(1)(d), 13(2) based on other evidence adduced by the prosecution. Your Lordship is hinting that other evidence plots.
The question. Okay. The court referred the following question of law for determination by the larger bench. Question is, that is actually the very first paragraph number 2, the order has been referred to. The question is whether, in absence of evidence of the complainant, oblique direct or primary evidence of demand of illegal gratification, is it not permissible to draw inferential deduction of culpability oblique guilt of the public servant under section 7 and section 13(1)(d) read with section 13(2) of the PC Act based on other evidence adduced by the prosecution. So it confines only.
This has been answered in paragraph 88, Lords.
88, okay.
The answer is that item number 7.
Just a minute. Let me come to that. Page
734.
88.
I'm sorry. Is para 88.
I'm coming to that paragraph.
In fact, they have answered in 8
what
paragraphs.
emerges from the aforesaid discussion is summarized as under.
Okay. Your Lordship, skip off the first 2 paragraphs. Your Lordship, turn to ground number 7. 7 and 8.
No. It reads like this: the proof of demand and acceptance of illegal gratification by a public
servant as a fact in issue by the prosecution is a sine qua non in order to establish the guilt of the accused public servants under section 7 and 13(1)(d) 2 of the Act. In order to bring home the guilt of the accused, the prosecution has to first prove the demand of illegal gratification and the subsequent acceptance of matter of fact. This fact in issue can be proved either by direct evidence, which can be in the nature of oral evidence or documentary evidence. Further, the fact in issue, namely the proof of demand and acceptance of illegal gratification, can also be proved by circumstantial evidence in the absence of direct oral and documentary evidence. In order to prove the fact in issue, namely the demand and acceptance of illegal gratification by the public servants, the following aspects have to be borne in mind. If there is an offer to pay the bribe giver without there being any demand from the public servant, the latter simply accepts the offer and receives the illegal gratification. It is a case of acceptance as per section 7 of the Act. In such a case, there need not be a prior demand by the public servants. On the other hand, if the public servants
means suppose gote case re jone public servant पाखु आसिला,
right,
तार पाखरे तार काम अछि,
right,
सीए किसी डिमांड करनी, पब्लिक सर्वेंट किसी डिमांड करनी,
right,
ये कहला आज्ञा मो कामटा कर देबे रखंतु ए पिलांग खर्च पई ये पई एमती एटा देला, and he accepted it.
Correct.
Here there is no demand,
Yeah.
but acceptance, and that can also be sufficient.
Simply accept the offer.
Yes, that will also be an offense under this 7 of the PC Act.
Exactly.
Okay, read out then.
Then Malas 2. On the other hand, if the public servant makes a demand and the bribe giver accepts the demand and tenders the demanded gratification, which in turn is received by the public servant, it's a case of obtainment. In the case of obtainment, the prior demand for illegal gratification emanates from the public servant. This is an offense under section 13(1)(d).
ये चाहिला दाबी कला एवं सेटाकू पूर्ण कला bribe giver and say accept kala, so it becomes the offense under 13(1)(d) 1 and 2. Okay, read next.
In both cases of 1 and 2 above, the offer by the bribe giver and a demand by the public servant respectively, have to be proved by the prosecution as a fact in issue. In other words, mere acceptance or receipt of an illegal gratification without anything more would not make it an offense under Section 7 and Section 13(1)(d)(1) and Roman 2, respectively, of the Act. Therefore, under Section 7 of the Act, in order to bring home the offense, there must be an offer which emanates from the bribe giver, which is accepted by the public servant, which would make it an offense. Similarly, a prior demand by the public servant, when accepted by the bribe giver, and in turn there is a payment made which is received by the public servant, would be an offense of attainment under Section 13(1)(d)(1) 2 of the
So
Act.
जदि भी डिमांड नथिबो जणे आनिकिनी वॉलंटरीली देला ता कामटा करै नवा पई एवं से ताकू ग्रहण कला सो इट वुड बी एन एक्सेप्टेंस
Honorable, are the illegal gratification not
आउ
necessarily
जदि
the
मोर जनकर इच्छा हैला बा से ता पई दाबी कला दाबी करिकिनी ब्राइब गिवर टू एक्सेप्ट कला then that would be 13(2). So in any case all these two things are necessary, but here is a case where neither there is demand
may please
nor
not-
there is an acceptance evidence in this case
Lordship,
because the two vital witnesses have not supported the prosecution
no,
case.
my entire endeavor to impress your lordship is Section 7 because on 13(1)(d) I have no hope now.
No,
Let's
no.
correct
Seven again. You just now read out. Na, come to number one.
Yes, ma'am. Therefore, under Section 7 of the Act, in order to bring up the offense, there must be an offer which emanates from the bribe giver, which is accepted by public servant.
So where is the offer? He has not stated I offered and he accepted. Here is a case. It's a question of simple recovery, and if you go to that line, recovery can be made from a person. Suppose somebody is not aware. You keep the money, bribe money inside his pocket, or you forcefully keep it.
Trusted.
Right.
Right.
You thrust it, or in his ignorance, you kept it under file or somewhere in the pocket, and you that is recovered. So that would not be a case of acceptance. Because he has not voluntarily accepted it.
I agree.
It may be unknowingly or forcefully it was thrust. So what this 7 says that the acceptance must be even if there is no demand, if the acceptance is also voluntary in nature, then also this 7 would be attracted. Now, if you
despite all those obstacles before me, my lords, my hope is pinned with paragraph 7. Let me place the fifth one, lords. I've read para 4 answering.
Para 4 Roman.
I just read another 2.
Okay. There is
Let's
no
turn to the same page, the paragraph 5 notes. That's answering the presumption part.
Okay.
Because my entire hope is pinned with presumption.
Right. Yes, please.
The presumption of fact, with regard to the demand and acceptance of obtainment of an illegal gratification, may be made by a court of law by way of an inference only when foundational facts are there. When the foundational facts have been proved by relevant oral and documentary evidence, what she's saying, not in the absence thereof. On the basis of the material and records, the court has the discretion to raise a presumption of fact while considering whether the fact of demand has been proved by the prosecution or not. Of course, a presumption of fact is subject to rebuttal by the accused, and in absence of rebuttal, presumption stands. Let me come to the 6 more. In the event of complainant turns hostile, or has died, or is unable to let his evidence during trial, demand of illegal gratification can be proved by letting in the evidence of any other witnesses who can again let in evidence either orally or by documentary evidence, or the prosecution can prove the case by circumstantial evidence. The trial doesn't await, nor does it result in order of acquittal, which has happened in this case.
That is the thing, because it may because the case usually lingers. Sometimes in earlier days, it was even one case is pending for 20 years, a draft case. You must and
because the chances
so
because death cannot be ruled out.
Okay. So
In that event, what
you
should
may
be the
so that all these things are there, but here is a case. Let us say that here the decoy has turned hostile, overhearing or shadow witness has turned hostile. Have you adduced any third evidence, either oral or by circumstantial evidence, so that the court can infer that there was any demand or there was any acceptance by the appellant from regarding that bribe money from the complainant? Tell me that which is that evidence.
Lord is correct. Well, on that way, my lords, all roads are closed to me. My lord, I just try to open up new doors for me on the basis of the evidence of the TLO, my lord. With the
TLO,
maximum
I
recovery.
accept that your TLO is a truthful witness.
With
Let us say
recovery.
only recovery.
One. And vis-a-vis the, you'll also permit me to place the para 7 notes. Para 7 next. They have answered within 8 paras.
Okay.
I've completed para 6 notes. Now let's turn to
7 in so far as section.
Yes, correct.
Yeah.
In so far as section 7 of the act is concerned, on the proof of facts
se boyta magelo
in
ki eta achi je boyta maga hala
in so far as section 7 of the act is concerned, on the proof of facts in issue, section 20 mandates the court to raise a presumption that the illegal gratification was for the purpose of a motive. The court is to raise a presumption that illegal gratification was for the purpose of a motive or reward, as mentioned in the said section.
Section 7 means suppose there is no demand, but it has been acceptance part you have proved. You prove that it's a voluntarily acceptance part. Then the court is to presume that it was accepted for on the ground that it was an illegal gratification for the purpose of motive or reward. To do some work at his level, he has accepted it. So unless that part is also missing here, because that acceptance part of kichi evidence mu seitpai कहली आपण जो TLO को धरिचंती TLO acceptance part देखिनी तारो only knowledge is only recovery.
Let's if lordship permits, let me complete
you see in such a case you should think of it that suppose these persons are independent witnesses and likely to turn hostile, right? So you do something. Now technology has improved a lot. So either something in pain, video camera, or something in the pocket which should be hard, what he is telling, what is the conversation. Those are the old methods that somebody would stand there and so many devices are there to
service now.
so
And
if you
with the amendment, my lord, this thing are admissible, this evidence.
right. Wow. But if you just go
they
on,
cannot wriggle out because of some factors.
This technology has improved a lot, and you can easily do something. Suppose he say that I have not gone there. That tracking would say that yes, this man has gone from the vigilance office to that office. So everything can be done. So these things, of course, this was a judgment of which year?
2000. It's a report in 2000, but December 15, 2022.
So no, this acquittal order is of the year.
In this case, my lord,
it's 2000.
2000.
So now it is.
And in fact, in the para 7 last line, my lord, the Honorable Supreme Court's my lord clarified that person. Of course, this presumption is also subject to rebuttal, but section 20 doesn't apply to section 13(1)(d)(2) of the Act.
Right, absolutely correct. That is the language is there. Only for 7 there is that presumption is there, and that is obviously because if you prove it by even indirect way that he has accepted it, then that would be the presumption would be there.
If lordship permits, my lord, I'll conclude my submission with 2 points only.
Yeah.
As a matter of duty, my lords, I will place before lordship, my lords, there's some portion of the TLO's statement and also the exhibit 12, the chemical exhaustion report.
TLO is PW?
1 minute. PW, my lords, TLO, PW 9, page 58. I'm afraid you may not throw any light on that point of what Lordship said, the factum of receipt.
PW, which is the TLO?
9, my lords.
PW 9 TLO, okay.
Page 58.
Okay. Which paragraph you want to place? Don't place the entire thing.
Yeah, Lordship, correct.
because-
I will not waste time. Your Lordship, turn to page 60, last two paragraphs.
Because he must have got some kind of signal from the overhearing witness.
From that onwards.
Yes, sir.
I along with
Okay, I along with, yes.
I, along with other members of the trap party, proceeded to Tikavali block office and reached Tikavali hospital at about 12:15 p.m. Thereafter, the complainant and the accompanying witness were asked to go ahead to the office of the accused. The other members of trap party followed them, maintaining distance. After some time getting signals from the accompanying witness, myself and other members of the trap party rushed to the office of the accused. After our arrival, I disclosed my identity and the identity of other official witnesses. I challenged the accused for accepting ₹1,000 towards bribe from the decor. The accused for some time remained mum and then stated that the money was forcibly inserted in his pocket. Thereafter, the hand wash of the both
You
the
see,
hands.
this line is very important also. This accused for the sometime remained mum,
and stated that the money was forcibly inserted in his pocket.
then stated that the money was forcibly inserted. This is the plea which he has taken
Taken
at
in
the
the
very beginning.
Defense plea.
You see, it is admissible under section 6 of the res geste. It says that it's not a plea which was belatedly thought of. This plea which is taken in
From the
313
inception,
stage.
from the inception.
So from the inception, he's telling that somebody thrust me. It's very relevant. That is why what the witness does after, or what the accused does immediately prior to that or after that, what statement he makes, that's
It has the
admissible
nexus,
under
it has a
section
nexus.
6 of the
So
Evidence
this is
Act.
not improvement or
Right, right. He's not that he consulted the advocate and thereafter he's taking this plea. Right from the very beginning, he's taking this plea that somebody came and this inserted, it was thrust in.
May I proceed,
Yes.
Lord, sir?
Yes.
Thereafter, the hand wash of both the hands of the accused was taken in two separate glasses of sodium carbonate solution, due to which the color of the solution turned to rose pink color. Samples of both the solutions were collected in two separate bottles, being duly sealed and labeled. Thereafter, being asked, the accused brought out the tinted currency notes from his chest side pockets. Then asked for my instruction, the official witnesses compared the number of the said GC note with numbers noted down by them at the IB in separate paper sheets. On verification, the number of GC notes tallied with the numbers noted in the separate sheet paper by the official witnesses. The said tinted GC notes were seized under a seizure list, where Exhibit 2 by 3 is my signature therein. I also seized paper sheets bearing the numbers of the GC notes prepared by the official witnesses at IB, my signature. That more thereafter he sees, and
Those things are there. There is no dispute about that. That let us say that you have laid.
Your Lordship may
evidence.
record my one submission, Lord,
Yeah.
that in the absence of the statements from the decoy and the shadow witness, Lords, they didn't extend solidarity to the prosecution case. Despite that, notes, the recovery part, the tented money is recovered. The numbers of the tented GC notes were compared with the note numbers mentioned in that preparation paper, and it tallied notes and the chemical as reports fully supports there was acceptance and it was recovered. Had there been no acceptance, there could not have been no recovery. And acceptance definitely by the accused, not as his salary, but as illegal gratifications, pursuant to some demands.
That is your
And the presumption is always can be resorted to, Lords, and the presumption is rebuttable. But in this case, mere bald statements, No cause and evidence has been adduced by the accused notes to substantiate this defense claim.
So your
That's all.
submission that wherever there is recovery, it should be presumed that there is voluntary acceptance. Think of a case. Think of a case. I just gave you this example. Somebody thrust money from your pocket into your pocket, or somebody keeps the money in your pocket without your knowledge, and it is recovered from you.
Then
Can
yes,
it be said that you voluntarily accepted it?
it's hazardous.
So, all right, take down. Yes, Mr. Sarangi.
Nothing left for me.
All right, then please take.
Only thing I can say, this is appeal against acquittal, the basics.
Okay.
Lordship
Have you
knows.
brought any citations about that principle? 83
Those-
Supreme Court, 308, or other thing. All right,
I
please take.
thought of then, I thought it
No.
will be
All right, please take.
two views are possible and all that.
All right.
Before you say.
Where is the paper book? First page, GCRL. Okay, no, that. You have written down all these things. All right. No, finding you have also to mention. You do it. Okay. Then you mention. Mr. Shangram Das, Lenin, standing counsel for the Vigilance Department. Challenging the impugned judgment, contended that even though in this case, the decoy bracket PW5 and the overhearing witness bracket PW2 have not supported the prosecution case and have been declared hostile by the prosecution. But the evidence of TLO, draft laying officer bracket PW9, is very clinching, and it proves the recovery of the tainted money from the possession of the respondent. And when the comparison of the numbers of the tainted notes have been made with the numbers earlier noted down, and it got tallied. It proves that the tainted money were accepted by the respondent, for which it was recovered from his possession. The Lenin Standing Counsel further submits that the change of color of the solution to pink of the hand wash as well as the pocket wash of the respondent.
Exhibit 12.
Uh,
Chemical examination is exhibit 12.
coupled with the chemical examination report bracket exhibit 12 substantiates that the accused, after accepting the same, kept it in his shirt pocket, and therefore, even though the two vital witnesses of the prosecution has not supported the prosecution case, the conviction of the it can be said that the prosecution has established the charges against the respondent, and the judgment of acquittal was not proper and justified. And counsel for the standing counsel for the Vigilance Department placed reliance in the case of Neeraj Datta versus State Government of NCT, reported in 2023 4 Supreme Court cases 731. Mr. Devasi Sadangi, land counsel appearing for the respondent, on the other hand, supported the impugned judgment and contended that in a case of this nature, to successfully establish the charges framed, the prosecution has to prove all the three aspects, that is, demand, acceptance, and recovery of the tainted money, tainted notes. And since the decoy and the overearning witnesses being examined as PW5 and PW2 have not supported the prosecution case, the demand as well as acceptance part are not proved. And merely because the TLO bracket PW9 stated about the recovery part, the same is not sufficient to hold the respondent guilty of the offences charged. Land counsel further argued that from the evidence of the TLO, it appears that when he was challenged about accepting bribe amount of rupees 1,000 from the decoy, he stated that the money was forcibly inserted in his pocket, and the same plea he has taken in his accused statement, and therefore the plea taken by the appellant, a respondent, right from the beginning is consistent, and in view of the statement made, it would be admissible as res geste under Section 6 of the Evidence Act, and in view of the scope of interference in a case of appeal against order of acquittal, since the London Trial Court has assigned reasons, clinching reasons for the same, and it cannot be said that the findings are perverse, the appeal should be dismissed. Adverting to the contention raised by the land counsel for the respective parties, law is well settled that in order to prove a charge under Section 7 of the PC Act, should take down my decisions there. Then, in order to prove charge under Section 13(2) reduce Section 13(1)(d) of the PC Act, these are the Coming to the evidence of the decoy who has been examined in this case as PW5, he stated that he had taken the work in question in Tikabali block in the year 1994-95 worth of rupees 65,000, and he got some payments, and for the balance dues he approached the JE, who is none else than the respondent in this appeal, and who told him to look after the matter by the assistant engineer. He stated that a report was lost before the vigilance officer, and the vigilance officer drafted the report and he copied the same, and the same was not written with his consent. The witness was declared hostile by the London Special Public Prosecutor, and leading questions were allowed to be put to him. But PW5 denied to have made any statement regarding the demand, acceptance, or recovery of the bribe money from the position of the respondent. In the cross-examination by the London Defense Counsel, he has stated that the BDO himself passes the final bill, and after completion of the work, they used to inform the BDO, who gives instruction to the concerned JE or officer for making necessary measurement, and after measurement, bill is prepared by the accountant. He further stated that he was called by the vigilance officer and asked to sit in a room where the documents were prepared, and he was asked to put his signature on different documents. And then he was asked to accompany them to Baliguda. And at the place of detection, after arrival of the vigilance officer, they caught hold of the hands of the respondent, but he did not know what else happened. He specifically stated that except signing on the documents, he did not give any statement before the vigilance officer. Therefore, from the evidence of PW5, the decoy, there is nothing either about the demand or acceptance or recovery of any tainted money from the possession of the respondent. Similarly, the overhearing witness being examined as PW2 has stated that in the IB, where the preparation was made, when he arrived there, he was introduced, the PW5 was introduced to all of them, and then PW5 explained that he was to get some money towards his bill, and the respondent, who was the junior engineer, told him to pay some money for getting the dues. But he stated that he did not know anything else of the case. He was also declared hostile by the public prosecutor, and the Lennon trial court allowed the public prosecutor to put leading questions to him. However, in the cross-examination by the prosecution also, he denied to have been examined by the investigating officer or stated anything regarding the demand, acceptance, or recovery of bribe money from the possession of the respondent. In the cross-examination by defense, PW2 stated that the preparation report and the detection report were not read over and explained to him, and he merely put his signatures on different documents as required and instructed by the vigilance officer. Therefore, the evidence of PW5 is also no way helpful to the prosecution. It is subparagraph. It is the settled principle of law that the evidence of the hostile witnesses cannot be totally thrown out of the board, and the prosecution or the accused can rely on the evidence whichever is helpful to their respective cases. However, the prosecutor, public prosecutor, by cross-examining these two important witnesses, that is PW 5 and PW2 have not brought out anything, we should help the prosecution in substantiating the charges against the respondent. The next para. The evidence of the trap laying officer PW9 no doubt indicates that when he got this signal from PW2, he along with the other members of the trap party rushed to the office of the respondent, and after arrival they disclosed their identity, and the respondent was challenged to have accepted rupees 1,000 towards bribe from PW2, but the respondent remained mum for some time and then stated that the money was forcibly inserted in his pocket. It comes out from the evidence of PW9 that hand wash of both the hands of the respondent was taken in 2 separate glass of sodium carbonate solution, and the color of the solution turned to rose pink color, which were collected into separate bottles. And the evidence of PW9 further indicates that the tainted currency notes were brought out from the chest shirt pocket of the respondent, and the numbers of such notes were verified with the earlier noted down numbers, and it got tallied, and the GC notes were seized under seizure list exhibit 2, and then pocket of the shirt was taken in sodium carbonate solution, which also turned to rose pink color, and the solution was collected in separate bottles. The chemical examination report, which has been marked as number mark is chemical examination? 12 indicates that phenolphthalein would be detected in each of the bottles which were sent for examination, but the evidence of PW9 coupled with the chemical examination report only substantiates about the recovery part. The contention of the Learned Standing Council that once there is recovery, the acceptance part is to be presumed is not correct. For example, if someone keeps the tainted money with the ignorance of a person in his pocket or in the official file, or thrust the same into his pocket from where it was recovered, it cannot be said that the person concerned from whom recovery was made has accepted it voluntarily. Clinching evidence relating to acceptance is to be adduced by the prosecution in a case of this nature. In the case of Neeraj Datta, bracket Supra, the question came up for consideration before the 5-judge bench was as follows. এটাକୁ ଦଉଛି page number 746 ଏଟାକୁ ଆପଣ bracket ଭିତରେ ରଖିବେ. While answering to this question, it has been held as follows. Paragraph number 88 रे जहाँ अच्छी पूराटा quote कर देंगे. है ना? 88 रो 88 1 2 3 4 कर देना up to 80 8 रो 8 पर्यंत जहाँ अच्छी है ना. Since the decoy as well as the overhearing witness have not supported the prosecution case, there is no evidence relating to offer to pay by the bribe giver. And there is also no evidence of acceptance of the offer. And therefore, Section 7 of the PC Act will not be attracted in view of the ratio laid down in the case of Neeraj Datta. Similarly, when the evidence relating to demand made by the public servant and acceptance of the demanded amount from the bribe giver is missing, the ingredients of the offense under section 13(1) bracket D bracket Roman 1 and Roman 2 of the PC Act are not attracted. The question of presumption under Section 20 of the PC Act that the illegal gratification was for the purpose of a motive or reward as mentioned in this section can only be for the offense under Section 7 of the PC Act and not for the offense under Section 13(1)(d)(1) oblique and Roman 2 of the Act. When the basic ingredients to attract the offense under Section 7 of the PC Act is lacking in this case, the question of raising presumption under Section 20 doesn't arise. Mere recovery of tainted money from the possession of the respondent, in my humble view, would not be sufficient to sustain the charges under Section 7 and 13 to reduce Section 13(1)(d) of the Prevention of Corruption Act. It cannot be lost sight of the fact that when the respondent was first challenged by the TLO (PW9) to have received the bribe money from the decoy (PW5), he stated that the money was forcibly inserted in his pocket. In the accused statement to question number 24, the respondent has stated that while he was in the office, 4 to 5 persons came to the office, caught hold of his hands, and forcibly thrust some money into his pocket. And thereafter he was asked to bring out the money from his pocket. And thereafter his hand wash was taken. The statement made by the respondent at the first instance that the money was forcibly inserted in his pocket is admissible as res gesti under Section 6 of the Evidence Act. And it cannot be said that there was time for thinking of a defense plea and taking the same during course of trial. The London trial court seems to have discussed the evidence on record carefully and came to the conclusion that there is absence of any evidence to prove the prior demand or acceptance of bribe on demand at the time of alleged draft, and mere recovery of money as stated by PW4, the Vigilance Constable, and PW6, the Tahsildar, is not sufficient to bring home the charge under Section 13(1)(d), read with Section 13(2) and Section 7 of the PC Act. Law is well settled that in a case of appeal against acquittal, if two views are possible, the view which favors the accused should be taken, and merely because the appellate court would have taken a different view if you would have been the trial court, that cannot be a ground to interfere with the order of acquittal unless the findings of the Learning Trial Court is perverse, based on no evidence on record, or inadmissible evidence has been taken into account for passing the order of acquittal. It should not be interfered with. After going through the impugned judgment as well as the evidence on record, I am of the view that there is no perversity in the impugned judgment passed by the Learning Trial Court, and it has been rightly held that the prosecution has failed to establish the charges under Section 13(1)(d), read with Section 13(2) and Section 7 of the PC Act. Therefore, this government appeal, being devoid of merit, stands dismissed.
If your Lordship permits, my Lords, may I submit one thing, my Lords? At the beginning of Lordship orders, my Lord, Lordship recorded my submission. Only I pray an addition of one line.
Yes.
My Lord, my further submission is that as the accused obtained or attempted to obtain the tainted money which was subsequently recovered, Section 20 presumption is to be inferred as he accepted it as a rewards, or
Give it in writing. I'll just mention it and also give the finding on it. If you want to say, give in a slip.
Section
Just
20 resorted.
take down. So in your words you put it so that I'll add it. Yes, next.
May I? Pardon, my lord. Occasion, my lord, the item 4, my lord. PT matter, my lord. Small
Four.
one. 4, my lord.
Yeah.
Scenario Sanjit Manti was there. My lord is asking that matter is small matter should taken up. So this junior is here, my lord.
You will argue the matter.
Yes, ma'am.
এটা টিকে রক্ষে দেবে ଆଉ ସେ ମିଷ୍ଟର ସଂଗ୍ରାମ ଦାସ ଯଦି କଣ ଦେବେ ତାହେଲେ ଲେଖିଦେବେ ସେ ତାଙ୍କ ସବମିଶନ. Yes. Argue the matter.
May I please, madam? Present appellant convicted under Section 323 of IPC for a period of sentence to undergo, my lord, 6 months and to pay fine 500 in default of for 15 days.
Now come to the first, let us come to the charges. What are the charges you are facing?
Charges
One of the charges 323,
323
right?
and 3 of SCST.
The other charge is 31 XI
Yes, ma'am.
of SC and ST.
Madam.
And you are acquitted of the charge under 3 SCST.
Madam.
Okay. Now you tell me that so far as the 323 is concerned, if we go to the charge at page 24,
Yes,
read out the charge portion.
yes, ma'am. Here charge you when the seal Goroda as follows. Firstly, that you on or about the 24th day of November 1996 at about 10 p.m. at Sunabeda, voluntarily causing hurt to Chandrama Benia and thereby committed an offence punishable under section 323 of the Indian Penal Code and within my cognizance.
Okay, so Chandrama Benia
Benia.
is the injured.
Yes, ma'am.
So is a male person or female person?
Female, ma'am.
Female. So she has been examined as PW.
PW1, ma'am.
Okay. So you are charged that you caused hurt
Hmm.
to PW1 on 24th November 1996 at 10 p.m.
Yes,
at Sunabeda, right?
yes, ma'am.
So the best witness is PW1.
Ma'am.
Let us come to the evidence of PW1.
Page 29, ma'am.
Page
29, ma'am. May I press, ma'am?
yes.
I do not know.
Please read it.
Point 1, ma'am. I do not know the person present in the document.
You are the person who is the sole accused or anybody else was?
So like this, ma'am.
So the very first line goes in your favor. I do not know the person. I do not know the person present in the doc. All right. Read it out.
I have seen him. I am a dump by caste and belong to a scheduled caste. The schedule is a Christian. The accused is a Christian. The incident took place about 1 year, 2 months back at about 4 p.m. in front of
At about 10 p.m.
10
Not
p.m.
4 p.m. Yes.
10 p.m. in front of Hall Hospital. At the time, I was working in the Hall Hospital. At the time, I was coming to the hospital from my house at U Zone to join on my duty. The accused came from my behind on a motorcycle and wanted to give me lift up to the hospital. When I refused, the accused forced me to sit on his motorcycle, pulling my sari. When I did not agree and proceeded ahead, the accused came to my front on a motorcycle and covered me. Then he pulled me by holding talked of my hair. I fall down. When I tried to get up, the accused kicked to my waist by his boot.
So
The-
this pulled me by holding tuft of hairs, one thing.
Madam.
Then he fell down. Okay.
And kicked to the waist.
Then kicked to the west with
Waist by
which is
his
boot.
boot.
Okay. Then repeat that 294 charges are not there. Leave that
But
portion.
Madam.
I
this
disclose
much.
the. Huh?
That
This
was
much.
all.
Assault part is this much.
Okay. Now you come to the information was given. All right. All right. I expressed.
PW4 months. Right.
No, just
Yes.
read the cross examination.
Madam. Cross-examination, madam. Point 4. I am working as a Aya in the Hall Hospital since 17 years. At the relevant time, my duty period was from 10 p.m. to 6 a.m. Seti work as ward boy. Seti is another witness man. Seti worked as ward boy in the Hall Hospital. He was also in duty at the time. Seti used to stay in the emergency room when there was no duty. Doctor, patient, sister are staying in that room. The emergency room was at the end of the ward. My husband was working hard. Next one, it is not a fact that I got the job in Hull with the help of the accused. It is not a fact that I am a Christian and the accused is a dog. Next, my waist was swollen. Dr. Satya Das treated me in the Hull hospital on the night of the occurrence. On the next morning, I sent information about the incident to my brother. On the arrival of my brother, I narrated the incident to him who lodged report at the PS. Next. It is not a fact that I have
So,
not stated
this lady is not the informant.
no, my
No,
lord.
no, his
Brother,
her
the
brother is in.
Okay. That brother is PW?
2, my lord.
Acha, PW2, comma, the brother of
50.
PW1.
Yes.
Yes, my lord.
When the victim narrated the story,
Ah,
she lost the
injured
That's
is the informant. Okay. All right. Then come to the paragraph number 7. Yes.
Yes, my lord. It is not a fact that I have not stated in my police statement that the accused pulled me holding my sari.
Just stop for it.
My lord.
Has he stated in chief examination that sari dhari taku tanla bari?
Yes.
my lord. Yes, my lord.
Kodi poor line ta dekhile.
এটা হচ্ছে
Right.
para 1
Para-
Pulling my
pulling my
sari.
sari.
Holding my sari.
Okay. That part is you said that it is not there. All right. It has been proved through the IO because he denies that no, I have stated. So IO is PW.
IOE PW6, man.
All right. We'll verify that line.
Yes, my lord.
PW6.
Yes.
my lord.
PW6 is the IO. Okay. Then next question, paragraph 7. It's not a fact. That's a
It
suggestion
is not a fact
that I have stated to the police that the incident took place near the school. Okay. Now he says that the incident took place in front of
the medical man,
Hall Hospital, right?
Yes.
The school.
Just a minute. Let us see. The accused came in. The incident took place in front of Hall Hospital. Okay, but the previous statement you have confronted that it is near the school. Okay, now continue that.
The school is situated almost half a kilometer
No,
from the
so
hospital.
these are not that it is adjacent to each other. So it's a half kilometer away, he admits. Okay.
I became unconscious due to assault.
Next.
I regained sense at the spot itself. Further, after a few minutes, it is not a fact that I have not stated in my police statement that I narrated the incident of assault to him. In Hall Hospital, there is a department of orthopedic. There was nobody except me and the accused when he assaulted me. It is not a fact that the accused did not abuse me in vulgar language. It is not a fact that I have not stated in my police statement that the accused came to my front in a motorcycle and covered me.
Okay. So this is also your confrontation that he has not stated in the police statement that the accused came to his front in a motorcycle and covered him when he refused to sit. So almost you are pointing out a few contradictions. One is that about the asking of the accused to sit and covering, of course. Then pulling your sari, number 2. Then the place of occurrence is also different. Now let us see how far this statement, this confrontation has been proved through the investigating officer, PW6. Okay, come to that.
Page 39.
Yes, which is that confrontation part? That is PW1. Acha. Paragraph number 8 re confrontation prove ହେଇଛି. Acha. ପଢନ୍ତୁ ସେଇ part ଟା.
8. It is a fact that PW1 has not stated before me that the accused pulled her by holding her sari, that she narrated the incident of assault to her brother, that the accused came to her front in a motorcycle and covered her when she refused to sit.
ନାଇଁ ବ୍ରଦର କଥାଟା କୋଉଠି କହିଲା କନଫ୍ରଣ୍ଟେସନ ଟା ଯୋଉଟା ହେଇଛି
My lord, PW,
PW1 ର the school is situated okay ଆଚ୍ଛା ଏଇଟା ଯୋଉ ପଚାରିଥିଲେ ଆପଣ ତାକୁ
my
ଯେ ତମେ କହିନାହଁ ତମେ କହିଥିଲ it's not a fact that I have stated to the police that the incident took place near the school ଏଇଟା ତ ତାକୁ ପଚାରି ବାହାର କଲେନି ସ୍କୁଲ ପାଖରେ ଘଟଣା ହେଇଛି ଏ ବିଷୟରେ ଯୋଉ ପଚାରିଲେ ଯେ ତମେ ପୋଲିସ ପାଖରେ କହିଥିଲ ଘଟଣାଟା ସ୍କୁଲ ପାଖରେ ହେଇଥିଲା
my lord's point 7
Para 6 million.
para 6
para 6 acha
I have mentioned second
uh,
time.
so and so I examined PW1 and 2 after examining I issued so and so I have mentioned that the that the incident took place on the way at so and so UP school which is at a distance of about he says that half a kilometer
half an hour
from the that hospital right
my lord.
so these are the basically the discrepancies
My lord.
now what about the doctor who is the doctor
Doctor my lord, PW
PW
No.
PW 3 man
3
3 yes ma'am.
3, 9, 5. PW 5.
ठीक से कौन
Sitting
PW
doctor. PW 5.
PW 5 come to the evidence of PW
It's my page 38 my lord.
she was examined on 25/11 that means on the next day
Next time.
and the time that has been given is 6 p.m.
My lord.
So 6 p.m. means if this occurrence has taken place
10.
on
10.
10 p.m. that means by that time almost 20 hours has passed right
My lord.
okay so
Paragraph
what he
2 means-
noticed is a bruise on the left side back that is one then abrasion is noticed on the left knee
Yes ma'am.
both the injuries have been opined to be simple in nature and caused by hard and blunt object age of injuries was within 48 hours injuries are possible by blow with a boot kick
Mm.
I have not mentioned in my report that injuries are possible by boot kick.
Blue by boot kick. My lord.
Injuries are possible also by hard fall on the hard and rough surface.
That also contradicts
Contrary.
by PW3.
कौन कौची
PW3.
कौन है PW3
That treating doctor.
PW3
Yes.
My lord.
कौन है पढ़ना
I know informant Chandrama Benia. The incident took place on 24/11/96 at about 10 p.m. At the relevant time, I was working as duty doctor at Hall Hospital, Sunameda. The informant was also working as female ward boy in that hospital. Her duty was to start at 10 p.m. on the relevant time. At 10 p.m. of that day, she came to the hospital and complained to me that she has been assaulted by one Dasil Gorodo. She complained pain in the back. So I gave her one injection and asked her to stay back in the hospital for the night. Next morning, she went home.
So at 10 p.m. on that day, she came to the hospital, complained to me
My lord.
that she has been assaulted by one Dasil Gorodo. That means this
But
appellant. She complained pain in the back I gave her one injection, asked her to stay back in the hospital for the night. Next morning, she went home.
Another things मतलब PW4
Yeah.
who take to hospital matter to the victim, but he did not disclose anything he has about the incident and when he had suffering.
I saw PW1 was lying on the ground. You are reading PW4 and crying due to pain near the boundary gate of the hospital. The accused was standing near PW1 keeping the motorcycle by his side. On my asking, PW1 stated that accused assaulted her. I requested the accused to help me for taking PW1 to the hospital, but he fled away. Then he took PW1 and left her in the so-and so. But I think PW1 has not stated that at this spot he disclosed anything before PW4.
No.
No. Cross-examination point
But
two, last two line.
in the chief also, she got that she has the in the doctor of Hall Hospital expressed their inability to treat me because of fracture. But there is no fracture.
No fracture. Simple injury. So, Mr. Tripathi,
Yes,
the law is that suppose it's a case of or charge is for higher offense, then these minor contradictions will not affect the prosecution case. But when the offense itself is minor in nature, that means 323, if there are contradictions in the statement, then that will affect the prosecution case. Here, the place of occurrence is different because he said, as he said at the initial state, that it was in the front of the hospital. Initially she stated that it was in front of the school, but in the place in the evidence he stated that it was in front of the hospital. Now, why she changed the venue? There may be some kind of reason, because if she would have said that it is at the place of the school, then the question would have arisen that why he had gone there, whether that school falls on the way from his house to the hospital or not. Since it was and in the hospital and likely that other persons would be there, and in the near the school in the at 10 o'clock nobody would be there. So that is why the reason she might have changed the venue to this place. And number two, about this pulling of sari. First he pulled the sari, that is also not there. And another thing about this PW1's evidence, this contradiction. The accused came in the front of the motorcycle in a motorcycle and covered him when he refused to sit. That is also not there. All right. Anything else you want to say, Samit? All right. Call him. Please take your seat. What is your good name, Mr. Karna?
Vikas Karnaman.
Vikas.
Karn.
You have not filed your appearance memo.
No, my lord, on
So
behalf Mr.
Sanjit Mahanti, you are asking. ଟିକେ ଡାକ 2 minute ପାଇଁ. Mr. Tripathi, I'm just coming within 2 minutes. Huh? This is item number 4. The appellant Dayasil Garoda faced trial in the court of London Special Judge Koraput at Jaipur in TR case number 161 of 1996 for commission of offences under section 323 of the Indian Penal Code and section 31 bracket XI of the Scheduled Caste and Scheduled Tribe bracket Prevention of Atrocities Act 1989. Hereafter SC/ST Act in short कर दूंगा. On the accusation that on 24/11/1996 at about 10 p.m., he voluntarily caused hurt to Chandrama Benia bracketary PW1 at Sunavada and at the same date, time and place, he not being a member of scheduled caste or scheduled tribe, assaulted or used force to PW1 was a member of scheduled caste, with intent to dishonor or outrage her modesty. Subfara. The Lenin Trial Court, by judgment and order dated 21/12/2000, has been pleased to hold that the prosecution of the appellant under Section 31XI of SC/ST Act is misconceived and cannot be sustained. However, the appellant was found guilty under Section 323 of the Indian Penal Code and sentenced to undergo rigorous imprisonment for 6 months and to pay a fine of ₹500, in default to undergo simple imprisonment for 15 days. The prosecution case, as per the first information report presented by Subhas Khilla, bracket PW2, before the officer in charge of Sunavada police station on 25/11/1996 is that on 24/11/1996 at about 10 p.m. his elder sister Chandrama Benia bracket PW1 was going to Hall Hospital to attend her duty from U zone. And at that point of time, near UP school of I zone, the appellant came in a motorcycle and asked PW1 to sit on the motorcycle for leaving her in the hospital. But when PW1 refused to oblige the same, the appellant got down from his motorcycle, caught hold of the tuft of hairs of PW1 and assaulted her on the back with his boot. It is stated in the first information report that the doctors are suspecting that PW1 has sustained fracture of her hand. The appellant also abused PW1 in filthy language and also in the name of her caste. For which PW1 became senseless, and when she regained sense, she found herself to have been admitted in HAL hospital. The doctor told the informant, bracket PW2, that it would be a police case and he should shift PW1 to NAC hospital, and accordingly, PW1 was admitted in the NAC hospital. On such first information report, Sunabada PS case number 118 dated 25/11/1996 was registered under section 354, 294, 325 of the Indian Penal Code against the appellant. PW6 Karthikeswar Samal, the officer in charge of Sunabada police station, after registration of the FIR, took up investigation of the case. During course of investigation, he examined the informant, bracket PW2, at the police station, visited HAL Government Hospital, Sunabada, along with PW2, and examined the injured, bracket PW1, and issued injury requisition to the medical officer He visited the spot on 26/11/1996, examined the witnesses, prepared the spot map Exhibit 4, arrested the appellant, and forwarded him to court. He seized the caste certificate of PW1 as per seizure list Exhibit 5, and on 2/12/1996 he received the injury report. And on completion of investigation, charge sheet was submitted. The defense plea is one of denial. In order to prove its case, the prosecution examined 6 witnesses. Take down. 5 documents were exhibited. Take down. The লেখিলেন one of denial. ঠিক আছে। The appellant examined himself as DW1 and proved his caste certificate, which was issued by the Tahsildar by Exhibit A. So also the record of rights Exhibit D. The London Trial Court, after assessing the oral and documentary evidence, came to hold that the delay in lodging the first information report is of no consequence so far as the credibility of the story of the prosecution is concerned. And basing on the evidence of PW1 and PW2, so also the doctor bracket PW कितने नंबर सकी डॉक्टर ना
PW5.
5 bracket PW5, it was held that the petitioner that the charge under section 323 IPC has been proved by the prosecution against the appellant. Mr. Bikas Karna, Learned Counsel for the appellant, contended that the evidence of the injured bracketary PW1 is full of contradictions. The place of occurrence has been shifted from near the school to the hospital. And even if the occurrence took place on 24/11/1996 at about 10 p.m., and the police station is just 4 kilometers away from the place of occurrence, which has been mentioned to be I-Zone UP School Hall. But all the same, the FIR was lost on the next day, that is on 25/11/1996 at about 9:30 p.m. And delay in lodging of the first information report has not been explained by the prosecution. And in view of the delayed lodging of the FIR, the chance of concoction of a case against the appellant on account of previous dispute cannot be ruled out. The Learned Counsel further submits that since the offense is minor in nature, minor contradictions counts much, and therefore it is a fit case where benefit of doubt should be extended in favor of the appellant. Mr. Priyabrata Tripathi, Learned Additional Standing Counsel, on the other hand, supported the impugned judgment and submitted that the evidence of the injured bracketary PW1 gets corroboration from the evidence of her brother bracketary PW2 so also the two doctors, that is PW3 and PW5, who examined PW1. And the contradictions, if any, are insignificant, and therefore there is no scope for interference in this criminal appeal, which should be dismissed. Adverting to the contention raised by the Learned Counsel for the respective parties and coming to the evidence of the star witness on behalf of the prosecution, who is none else than PW1, Chandrama Benia, comma, it appears that she stated in her evidence that in the first line that she did not know the person present in the dock. LC ata karo. Her evidence was recorded on 9th February 1998 by the London Trial Court, and the order sheet dated 9/2/98 indicates that the appellant was present in the dock. And therefore, such type of statement made by PW1 that he did not know the person present in the dock is a very damaging one, and it raises doubt about the involvement of the appellant in the crime in question. However, the PW1 stated subsequently that the occurrence took place in front of HAL Hospital at about 10 p.m. It has been confronted to PW1 that she had stated to police that the incident took place near the school. Though she denied to have made such statement before the IO, but it has been proved through PW6, the IO, that when he examined PW1 and PW2 and issued requisition exhibit 3/3, he mentioned that the incident took place on the way at iZone UP school. In fact, in the first information report also, it is mentioned that the place of occurrence is near iZone UP school hall. Stop. PW1 has stated in her evidence that the school is situated almost half a kilometer away from the hospital. Therefore, the place of occurrence, as stated earlier by the informant, so also by the injured, has been changed, and the prosecution has not offered any explanation as to why such a change regarding place of occurrence has been made by the witnesses during trial. It may be that the school would be an isolated place, and if a statement is made that the incident took place near the school, they would not get any other witness to corroborate the evidence of the injured because of the time factor when the occurrence stated to have taken place, and that may be the reason for changing the place of occurrence from school to hospital, near the hospital. Though the injured bracket PW1 stated that the appellant pulled her by holding her sari and the appellant came to her front in a motorcycle and covered her when she refused to sit. But it has been confronted to PW1 the previous statement of PW1 has been confronted to her and proved through the IO bracket PW6 that she has not stated in her 161 CRPC statement that the appellant pulled her by holding her sari and that the appellant came to her front in a motorcycle and covered her when she refused to sit. ATTS law. মনুপাত্র বার করো। सर्च मारो लेकर delay in lodging FIR search enter f.i.r दे दियो f.i.r दियो r पर डॉट दियो enter come to Orissa this side नहीं सेठी नहीं से जो ऊपर हाँ से चिन्ह से चिन्हटा भी करो हाँ Orissa come down हाँ ऊपर रहला हाँ Orissa ऊपर है ओके क्लिक इट गोटे थर क्लिक करो बाहर जो okay then you come to the judge okay click it come to S.K.SAHOO click down scroll down okay that 72 decisions come down okay that click it you go now the injured bracket PW1 has stated that after the occurrence she was first taken to Hall Hospital where the doctors expressed their inability to treat her because of fracture and they advised her to go to NAC hospital. No doctor from Hall Hospital has been examined, nor as per the medical examination report proved by the prosecution, the PW1 has sustained any fracture injury. He has sustained a bruise on the left side back at posterior axillary line at the level of 8th and 9th rib space and an abrasion on left side of the left knee, and both the injuries were open to be simple in nature by the doctor bracket PW5 who was the medical officer of Government Hospital Sunabada. PW2, who is the brother of PW1, has assigned a different reason as to why the why PW1 was not admitted in the Hall Hospital and took admission in NAC Hospital. He stated that though the occurrence took place near the hospital gate, since they expressed their desire to file a police case, the doctor of Hall Hospital told them to take admission in NAC Hospital, and accordingly, he took PW1 to her house since the hospital time was over, and then they went to the hospital at about 5 p.m. where PW1 was admitted. Even though, as per the formal FIR, the place of occurrence is near iZone UP School Hall, and it situates at a distance of 4 kilometers away from Sunawada police station. And the injured bracketed PW1 has sustained simple injury, but no report was lodged on 24/11/1996. But it was lost on 25/11/1996 at 9:30 p.m., which is almost 24 hours after the date of occurrence. In case of Thuliakali versus State of Tamil Nadu, reported in AIR's 1973 Supreme Court 501, it was held that first information report in a criminal case is an extremely vital and valuable piece of evidence for the purpose of corroborating the oral evidence adduced at the trial. The importance of the report can hardly be overestimated from the standpoint of the accused. The object of insisting upon prompt lodging of the report to the police in respect of crime of an commission of an offense is to obtain early information regarding the circumstances in which the crime was committed, the names of actual culprits and the part played by them, as well as the names of eyewitnesses present at the scene of occurrence. Delay in lodging the first information report quite often results in embellishment, which is a creature of afterthought. Stop. On account of delay, the report not only gets bereft of the advantage of spontaneity, danger creeps in of the introduction of colored version, exaggerated account or concocted story as a result of deliberation and consultation. It is therefore essential that delay in lodging the first information report should be satisfactorily explained. In the case in hand, I am of the humble view that the prosecution has not satisfactorily explained the delay of almost 24 hours in lodging the first information report. And therefore, the possibility of concoction of the prosecution case cannot be ruled out. In view of the foregoing discussions, when the place of occurrence has been changed, when there are contradictions in the evidence of the victim, bracket PW1, with reference to her previous statement, comma, which even though minor in nature, but has its significance in a minor offense like 323 of the Indian Penal Code. And when the delay in lodging of the first information report has not been satisfactorily explained by the prosecution, I am of the humble view that the conviction of the appellant under section 323 IPC is not sustainable in the eye of law. Accordingly, the same is hereby set aside. The appellant is acquitted of the charge. The appellant is on bail by the order of this court. His bail bond, his personal bond and surety bond stands cancelled. Put a note of appreciation on Mr. Karna. Okay, but it's a regular appeal, so no fees is there. Okay. So anybody is ready after lunch to argue the matter?
I am in item 47, that is a vigilance appeal.
But the other side should be ready, Mr. Mahapatra. You should have earlier intimated them that
Your Lordship,
Item number 6 also.
6 there.
7
six there, 6 is mine, but it was up for 201 appeal. I could able to get the brief yesterday night. There is no paper book with me.
No, you can receive the paper book here.
So I intimated him to give me the paper book. Had he given the paper
It
book?
is not available in the office. Okay, he is telling that he will make out a Xerox copy and hand over to you during course of the day.
So
Okay.
I thought if it was given in first hour, I could have.
No, it's all right.
I
You
could have
will get it during
argued
course
it
of the day.
now.
You'll get it during course of the day, and you get ready to argue it in the next week. What is your item?
May I request your Lordship? Your Lordship, earlier I was requesting for item 47. One day I was.
There is no problem. Once you tell the other side and they are ready, I have no. I am here to take up the cases. But the Vigilance Council.
What is I am praying, your Lordship once accepted my prayer and said that
why don't you just tell the Vigilance Council to remain present after lunch so that a date can be fixed? It can come in the. Okay, I'm coming at 2 o'clock. I can take up this matter. Okay. Yes, Mr. Panda.
Item 33, if that is taken up tomorrow, next week at the top millers.
Top means if the.
That is Mr. Sarthak Naik will appear. So since it is 33.
Why don't you, if a phone call is given and he remains after lunch over hybrid mode, so the date can be fixed so that if you take your chance and you, what is your item?
Item 7, ma'am.
7, you are ready?
7 is.
What is the offense here?
EC Act, Your Lordship, 3 months conviction.
Okay, I will take up after 2 o'clock. Okay.
Your Lordship, vigilance. Excuse me.
Mr. Mahapatra is ready with one matter. But it
Item
is,
47.
see,
You need paper books also, Malak.
paper book you can receive. I'm asking him.
नहीं ମୁଁ paper book ମୁଁ ଦେଇଦେବି ମୁଁ ତାଙ୍କୁ ଗୋଟେ ଦେଇଥିଲି ଆମେ ସେତେବେଳେ ତିଆରି କରୁଥିଲୁ 10 ବର୍ଷ ହିୟରିଂ ହେଇଥିଲା
It's all right. He will give you paper book.
Malak.
So
ମୁଁ କାଲି
get ready
ଦେଇଦେବି
if it is possible. You can take up this matter next week. Okay. Next week on Thursday it will come.
Can it be on 24th, Malak, instead of 17?
Okay.
Your Lordship is suggesting 24th, Malak.
All right.
Great.
24th is supplementary, yes.
Great.
Get ready, Mr. Mahapatra, with that written note of submission, citation, whatever it may be.
My Lord, I have given everything,
Okay.
even the
It is already given in the
exhibits are I have given.
No, it's all right. If then please pass on your written note of argument to Mr. Rizvi along with the citations. Okay,
And
along with the paper book. Mr. Rizvi, get ready.
I will give him tomorrow.
Okay.
May I?
Yes.
Item 50 CBI matter. Item 50. CBI matter may be fixed in date.
No. CBI matter, for that you just are to intimate Mr. Naik so that if he appears, you know that only one advocate is there. So for ready in the hearing matter. So the moment you should get ready and you should wait when your turn comes. If nobody is there, your matter can be taken up. Once it is made as part hard, it will come to the top. So there is no problem. But for that, since it's item number 50, you tell Mr. Naik that to remain present and you make a mention in his presence. So,
another 38 vigilance matter. 38 vigilance matter practices. Small matter. 38.
Ask him to. There is no problem. I'm taking the matter. I'm here to take up the matters.
I may be pardoned, Lords.
Yes.
My senior had mentioned item number 33. Mr. Naik's associate is there online.
Your Lordship, I am appearing on behalf of Mr. Naik.
Yeah.
Your Lordship, can we fix the matter to next week, Lords? Item 33, which my learned senior had
Your Lordship, I pray that the matter may be fixed from the week commencing 1st of September, Your Lordship.
Okay. Which is that item?
Item number 33, Your Lordship.
33.
You have received the paper book?
We have the
okay. Okay, it will come. Mr. Naik is here. Mr. Naik, two matters of CBI has been mentioned. Your associate, of course, there. Mr. Panda is mentioning about item number 33.
33.
And it is told by your associate that you have got the paper book with you. He is requesting it to be fixed in the first week of September. So it will obviously come on the Thursday.
Yes, Your Lordship.
Okay. Okay. It will come in the week commencing from 11 because in that week there is 2 holidays are there, 6 and 7. So it will be listed on 14th. Okay. So Mr. Panda, it will come on 14th.
I'm obliged, Lords.
Okay. Yes. The other matter.
Item 50. 50.
50. I do not know whether paper book is available with you. No, tell the date.
It will take half a day. It will take. It's a short matter.
Short matter. It can be done.
Yes.
Also on that day, let us keep those two matters on that.
Yes,
day.
Your Lordship.
All right. So that also item number 14. Okay. September 14. Both these matters. One is item number 33. The other is item number 50. Okay. All right. So let's.
Can I pray on 24th at the shop?
No, it will be there. There is no problem. You just make a mention once I have stated it. All right. Yes, what is your item?
Item 7. Two connected appeals, Your Lordship. Two appellants.
So the charge is misappropriation of 100 kg BPL rice, right? In contravention of clause 3(1) of the EC Act and clause 8 of the Orissa Rice and Paddy Control Order 1965. Come to the judgment.
Lordship.
Page 27, running page 27.
Read paragraph 2, the prosecution case.
Lordship. Briefly stated, the prosecution case as disclosed from the FIR lodged by Marketing Inspector Bisoi, who's PW2, is that on 1st of September 1999, at about 1 p.m., when he was moving in Bisnoi market, the villagers of Asansikal, namely Biswesar Sethi, Chandra Mahakud, and others of village Mahakan, gave a petition at about 1 p.m. to the effect that one Narendra Sethi of Asansikal was proceeding with rice in his cycle by collecting the same from Secretary Bisoi Grama Panchayat retail shop, which was located at the weekly Hat Padia of Market Campus. They detained Narendra Sethi with his cycle and rice. When he asked about the authority of the rice, Narendra Sethi did not produce any document in support of rice except one APL card bearing number such and such, in which no entry was made about the supply of rice on 1/9/99. He also verified the sale register of Bisoi Gram Panchayat and noticed that the secretary, who was one of the appellants, Manoj Kumar Mann, had issued 1 quintal of rice in 5 ration cards, wide number such and such of Ravindra Sethi, such and such of Siba Sethi, such and such of Subhasini Sethi, such and such of Narendra Sethi, and such and such of Gangadhar Sethi, of each 20 kgs. So in this way, the secretary had given 1 quintal of rice to accused Narendra Sethi. The marketing inspector also verified the sale register of the secretary of Bisoi GP, who had issued 20 kgs of rice, of APL rice, in card number such and such. Accused Narendra Sethi of village Asansikal could not produce the ration cards in support of the BPL. He was seized the same, that is 1 quintal of rice, 1 cycle, and 1 APL card bearing number such and such from him. He also seized 1 sale register in 2 numbers from the secretary, Bisoi GP, on production by accused Manoj Kumar Mahanti. He submitted FIR before the OIC Bisoi PS, and the OIC registered the case under Section 7 of the EC Act against the accused persons. In course of investigation, he seized the rice, documents and connecting cards and left the seized BPL card in Zimma of accused Narendra Sethi, White Exhibit 18. And on his transfer, he handed over the further investigation of the case to the ASI Bisoi PS. On 1 September 99, the ASI, whose PW7, took charge of the case and seized the sale register and other connecting documents. After completion of investigation, he submitted charge sheet against the accused persons. The defense plea is one of complete denial. Under 313 CRPC, accused Narendra Sethi has stated that he had taken 1 quintal of BPL rice from accused Manoj Kumar Mahanti, and accused Manoj Kumar Mahanti has also stated that accused Narendra Sethi had taken 1 quintal BPL rice from him. Now the witnesses in the present case, my lords, PW1 is one Barsingh Naik, PW2 is one Swapneshwar Mishra, who was present at the scene of occurrence. PW3 is one Chandra Mahakud, 4 is one Chandrasekhar Mohanty, 5, 6, 7 are the IOs in the case who have investigated the matter. Now in the present case, my lords,
come to paragraph 6.
In course of argument, the learned special PP contended that PW2, 3 and 4 have clearly stated that accused Manoj Kumar Mahanti had given 1 quintal of APL and BPL rice to accused Narendra Sethi by contravening clause 3(1) of the EC Act and clause 8 of Odisha Rice and Paddy Control Order 1965. So the accused persons may be convicted on the basis of their evidence. On the other hand, the learned counsel for the defense contended that the prosecution has failed to prove its case as the license of accused Manoj Kumar Mahanti has not been proved, and when the guideline of the license has not been proved for that the accused persons are no way connected with the offence levelled against them. It is admittedly a fact, my lords, that the license of Manoj Kumar Mohanty was not exhibited or proved by the prosecution in the present case. That being apart, the
What
petition,
license?
my lord,
What license you want?
that Manoj Kumar Mohanty, he had the authority to issue BPL rice to all the villagers. So there's a license under the EC Act that is issued to him, which is not proved by the prosecution. And
No.
in
It is your case that you are authorized to issue such APL and BPL rice, then you should come forward to see that this is my license, so I have been permitted, and in accordance with the instruction I have issued to these 5 persons, which was also permissible, and these are the relevant entries made to that effect.
Entries are made, your lordship, and the ration cards, 5 ration cards of 5 villagers have been seized. Now, in case the prosecution does not prove the license of one of the appellants, then how the entire genesis of the case?
Well, I do read on.
PW3 has stated that on 1999 he was marketing inspector of Bisoi block, and on that day he went to village.
Where from you are reading?
Lordship, para 7.
Okay.
Lordship has it?
Yes.
And on that day he went to village Avani Shekhar and found the villagers had kept 1 quintal of rice from accused Narendra Sethi. Narendra Sethi had bought 1 quintal of rice from accused Manoj Kumar Mohanty. When Narendra Sethi did not produce the cards in which he had bought the rice, he seized 1 quintal of rice and 1 cycle. He also seized the sale register in 2 volumes, and he also seized 1 APL card from the accused Narendra Sethi. Further, he stated that on 1999, while he was at Bisoi at that time, the villagers gave him a petition as accused Narendra Sethi was illegally taking rice of 1 quintal from accused Manoj Kumar Mohanty. The accused gave an endorsement that he was carrying 1 quintal of rice in 4 BPL cards and 1 APL card. That is my ground, your lordship. That the ration cards that were seized from the present appellant, there were 5 ration cards on which those 20 kgs each rice were issued. The appellant was merely transporting the rice for the said villagers. That is my ground, your lordship. Exhibit 4 is the endorsement with signature of the accused on the public petition. On his inquiry, he found accused Manoj Kumar Mohanty had given 1 quintal of rice.
Suppose if you do not dispute about the seizure of 100 quintals of BPL and APL rice from your possession, that too in 5 bags, and each bag containing 20 kg.
Lordship.
And you are having 5 ration cards with you.
Lordship.
That were also found.
Lordship.
And your case, if it is that those 5 persons had sent you
Lordship.
to the concerned person, that means Manoj Kumar Mohanty,
Lordship,
to bring the rice, then question is that suppose X does not come, in the name of Mr. X, the card is there, and X does not come to the to receive the rice, and he sends Y to go and receive the rice on his behalf. Then what is necessary? There must be some kind of authorization, and he should also produce that authorization and sign that I am receiving this rice on behalf of Mr. X. Otherwise, suppose somebody steals the ration card of Mr. X and goes and hand over to that person who is distributor, and he permits the rice to be lifted, then the actual person would not get it. A thief of that ration card will get the rice. So the 2 things are necessary. Your claim is that you are simply transporting. because the ration card stands in the name of A, B, C, D, E, and you are just carrying that rice and you are supposed to deliver it to them. If that is your case, then the next question would be that whether there was any authorization given by ABCDE to you to receive such rice, or you have somehow rather obtained their ration cards to get the rice. So if they have authorized and they come forward and say that yes, we have entrusted Mr. X to receive the rice on our behalf, this is our authorization letter, and on our behalf he has received it. So matter is something different. Now, as it appears,
I have taken that.
No, you have taken that plea. Mere taking of plea would not do. You are to prove some certain more things.
Lordship.
If you say that I have received, it is your case, I think it is your case that you are having 5 ration cards with you.
Lordship.
It stands in the name of ABCDE, and each of those person has been is entitled to get 20 quintals of rice, and you were sent by those 5 person to to Manoj Mahanti, and you received the rice. So once you receive the rice, means in the register also your name would be there, your signature would be there.
It is reflected.
Right.
Lordship.
So your signature is there in the register of Manoj Mahanti.
Lordship.
And Manoj Mahanti also said that he has handed over rice to you.
Lordship.
Question is that whether that rice which was meant for ABCDE, they have authorized you to receive it on their behalf or not. So the onus shifts to you because the rice was seized from your possession. You are having the ration cards of 5 persons. So have you examined any of them, ABCDE?
Lordship, I have not introduced them as
any authorization letter of ABCDE has been
Lordship,
produced.
This is of the year 91. Now these are all villagers, rustic villagers of that time.
अरे rustic villagers in authorization देलेनी हमको पठे दे. Let us say accept your case
I am
that
saying orally that they have
नहीं orally जे सेमान आसी कहबे ना आपण कहि देबे सेमान मते orally कहितले सब everything if you will say.
Please come to para page running page 25 paper book page 9. In the middle portion, the learned trial court has held in para 3 of PW2 has stated that there is no general instruction that one man can take rice by any
पढ़छंदी कहले
in the middle portion, my lord.
अच्छा ये चिन्ह दियो.
Paper book page
There is
9.
no general instruction that one man can
take rice
by
any card from the secretary. So also PW4 has stated that in para 4 that there it is the duty to take rice of one consumer, but there is no provision to take rice for 5 consumers by one person. So violating the terms of and condition of section 3 bracketed 1 of ECA. So one man cannot take rice of 5 consumers. That is observed.
From where does PW?
That's not. Mr. Mishra, suppose some persons have difficulty. Maybe their personal work is there. Maybe they are suffering from fever or from any ailment, or they are so old that they cannot go to receive it. So they entrust a person to go and collect it, and they may pay something to them, and or they may give some rice to them also, the person who is collecting on their behalf. That was the understanding between ABCDE and this man, this accused. And with that, the man goes and receive it. It's all right that it is not prohibited. If it is prohibited, matter is different. What they say it is
there is no instruction to that way that one man cannot take 5 persons ration.
There is in the EC Act or in the Odisha right paddy control order, there is no prohibition on transportation.
I'm telling you about that. That there is Suppose somebody is having a auto rickshaw, auto with him,
Yes, sir.
and the depot of the main is situated at a distance, and that man is going, so they just authorize to you bring it, we'll give you something. Maybe in
my lord, the authorization is required.
that I was asking him.
That I've brought out in DW1's evidence also. It has been brought out that the village of the said villagers were given their ration card is 15 para 9 ta tolo paratar likha hai.
All right, you do one thing. You read out that from wherever you have left it.
Again. I was at para 2.
You are reading in paragraph
2.
No, page number 20. I think you are reading. Paragraph 7 you are reading.
Lordship, para 7. Sorry.
Of the judgment I am telling.
Lordship. May I please?
Yes, sir.
On his inquiry, he found accused Manoj Kumar Manthi had given 1 quintal of rice in 4 BPL cards in 1 APL card to accused Narendra Sethi, and accused Manoj Kumar Manthi had entered this in his sale register. APL card number such and such was in the name of Gangadhar Sethi, and accused Manoj Kumar Manthi had not entered in the said APL card regarding issue of rice, but he had entered the said issue of rice in the sale register.
Another thing which is now suppose you are utilizing the particular card, BPL card or APL card, for taking the rice, then there would be two entry.
Lordship.
Entry in the register of the distributor, Lordship, and also entry in the ration card.
Lordship.
So here, as it appears, these APL and BPL cards are having no entry that it was issued, because that is the proof that this month, suppose you are entitled to get 20 kg.
Lordship.
So for the month, there would be entry on this particular date. He has received 20 kg, and the signature of
the distributor,
would be there in the
card.
ration card. Similarly, your signature, that means the person who is receiving it, his signature would be there in the register of the distributor. Okay, so that would match, and that would substantiate that is on this particular date this person had received this much of rice from the distributor. Here the entry is there in the that means distributor's register shows,
and only 1 APL card he has not entered. Other 4 BPL cards entries are there.
Oh,
APL, only that APL card is not entered.
Just a minute. Come to that.
Lordship, I'll read it again. Manoj Kumar Manthi had not entered in the said APL.
Where are you pressing?
Lordship, page 20.
Which line?
Lordship, around 15 lines from the bottom.
On his inquiry, he found that accused Manoj Kumar Mahanti had given
1 quintal of rice in 4 BPL cards and in 1 APL card. To accused Narendra Sethi and accused Manoj Kumar Mahanti had entered this in his sale register. APL card number such and such was in the name of Gangadhar Sethi, and accused Manoj Kumar Mahanti had not entered in the said APL card regarding issue of rice, but he had entered the said issue of rice in the sale register. Lordship, if the intention of the accused persons was to deprive the said Gangadhar Sethi of the rice, they would not have entered in their own register, because that register is under scrutiny by the government. Exhibit 5 is the said APL card. He has not entered in the above APL card rice, but had entered in the sale register of 7799. Exhibit 6 is the sale register maintained by accused Manoj Kumar Mahanti. Exhibit 6/1 is the entry regarding issue of rice to accused Narendra Sethi. 6/2 is his signature and endorsement which had verified the register. On 1/9/99, he had verified the sale register and found 20 kg of rice was issued in the name of Gangadhar Sethi, but it has not been mentioned in his APL card. Exhibit 7 is the said register. Exhibit 7/1 is the entry made by accused Manoj Kumar Mahanti. Exhibit 7/2 is his signature and an endorsement dated 1/9/99. He seized 1 cycle, 1 quintal of rice, 1 APL card from the accused Narendra Sethi and gave the seized articles to the police. ACSO Rairangpur issued the tally register in favor of GP Secretary Bisoi GP via Exhibit 8 on 27/8/99. Quantity That quantity is
98.
58 of BPL rice was to issue to the store agent with a direction to give Manoj Kumar Mohanty. The store has delivered the said rice on 31/8/99 to accused Manoj Kumar Mohanty. Exhibit 8/1 is his signature and endorsement. Card number such and such in the name of Rabindra Sethi, card number such and such in the name of Sibbo Sethi, card number such and such in the name of Subhasini Sethi, and card number such and such in the name of Narendra Sethi are BPL cards which were seized by the OIC. Exhibit 9, 10, 11 and 12 are the said BPL cards of the above noted person. At the direction of the CSO Mayur Bhanj, he sold the seized rights and deposited the sale proceeds in the treasury white challan number such and such. Is the said challan. Exhibit 13 is the said challan. In cross-examination, he has stated that he had kept the treasury challan BPL cards with him till 13/7/2000. He had not given any endorsement in the application of the public dated 1/9/99. He had not given any endorsement that accused Narendra Sethi has scribed Exhibit 7. So from the evidence of PW2, it transpires that on such and such date, he had received 1 quintal of rice from accused Narendra Sethi and was carrying the same by cycle, and the said rice has been seized by PW2. Further, the marketing inspector had checked the sale register and also the APL card in which accused Manoj Kumar Mohanty had not entered in the APL card about the sale of rice, but he had entered the same in the sale register dated such and such. So I think 20 kgs of rice was issued by Manoj Kumar Mohanty. It was not entered in the APL card regarding the issue of rice, but he had entered it in the sale register. Though 20 kg of rice was issued in the name of Gangadhar Sethi by Exhibit 7/1, hence it is clear that accused Manoj Kumar Mohanty had misappropriated 20 kg of rice of one Gangadhar Sethi, to which he had not entered in his APL card, but had entered in the sale register and such and such. The learned court below has come to a conclusion already that they have misappropriated, your lordship. The Gangadhar Sethi, now every family gets a particular amount of ration in every month. When Gangadhar Sethi goes to collect his ration from the said distributor, your lordship, there will always be a question that whether he has received the rice or not. Only difficulty here is that it was not entered in the APL card, but that has been corroborated by the entry in the register of the distributor. Further from the
What about the deposit of the amount?
Lordship, he had, that is the CSO who had.
Oh, no, this 100 quintal, for that,
he has deposited the entire amount. Why I placed that, your lordship, earlier. At direction of the CSO Mayur Bhanj, he sold the seized rice and deposited the sale proceeds in the treasury challan. The entire amount was collected from him, and that thereafter he was directed to deposit the entire amount.
No, from whom it was collected?
From Manoj Kumar Mohanty.
Okay. Because I think he is not supposed to get anything from this BPL card holders. BPL card holders should get free of it, or they may get a very many nominal price like that, 1 rupee or something like that. What is the evidence?
He is not supposed to receive any money, your lordship.
Right. So that is exactly I'm telling. But some rices are also given at 1 rupee or 2 rupee.
Yes.
So otherwise, BPL card means full free.
Lordship.
Okay. So
the OIC has sold the seized rice and deposited in the challan. The appellant Manoj Kumar Mohanty has not received any money from Narendra Sethi.
Right. No, after the seizure, it was sold. On the way, it was seized.
Lordship.
Okay. Now, no. So one finding is there. Hence, it is clear that accused Manoj Kumar Mohanty had misappropriated 20 kg of rice of one Gangadhar Sethi,
APL card holder,
to which he had not entered in his APL card, such as I said, APL card, but had entered the sale register on so and so. Further, from the evidence of PW2, it is found that so and so the accused Manoj Mohanty had given 80 kg of rice to accused Narendra. So the above noted person have not come to take their BPL rice from so and so. So it is clear that accused Narendra Sethi had brought the cards of the above noted person and received 80 kg rice from so and so with connivance
Lordship, now the learned court below has held, so it is clear that accused Narendra Sethi had bought the cards of the above noted person, received 80 kg of rice from Manoj Kumar Manthi with convenience. Pardon, my lords. 4 lines above that, accused Manoj Kumar Manthi had given 80 kg of rice to accused Narendra Sethi on such and such date. Though the above noted persons have not come to take their BPL rice from accused Manoj Kumar Manthi. That finding, in my opinion, is wrong, Your Lordship, because the rice once seized, it stays. Once it is seized, it stays with the OIC, who has to either, if it's of perishable nature, he has to sell it off before the essential goods perishes, and has to deposit the same in the treasury challan, in the treasury wide challan. So the opportunity for these persons to collect that from Manoj Kumar Manthi was never there. On the way, when Narendra Sethi took the rice, got out of the shop, he was apprehended by these people and the rice was taken away from him, including his own 20 kg of rice. Narendra Sethi is also one BPL card holder. 20 kg of rice from that 100 kg was belonging to him also. And that particular 20 kg of rice was also sealed, and that it was sold by the OIC, which has been mentioned in the judgment. So these persons, there was no occasion for these persons to approach Manoj Kumar Manthi and take their rice or to prove their case. In any case, when I have made a statement that the said rice belonged to 5 different persons, those persons were not examined by prosecution or brought to the front, or neither their statements were recorded. Only on the basis of one fact, that the said entry in the APL card regarding 20 kg of rice was not done in the APL card, but it was there in the register. That is the only basis on which the entire...
No, why you think that the prosecution should have examined?
Lordship, the burden is on me to prove it. Once I am caught, I understand my lordship's...
It was recovered from your possession.
Lordship.
5 cards were recovered, rice were recovered, 5 bags.
Lordship.
So once it was within your special knowledge, because you are taking the plea that it is the ABCDE who has entrusted me to receive the card, to receive the rice. So if that is within your special knowledge, once it is within your special knowledge, then as per 106 of the Evidence Act, you are to prove it, not the prosecutor.
Lordship, admittedly, the place where the distributor is...
Come to 106. Under 6 of the Evidence Act, it says that burden of proving fact especially within the knowledge. When any fact is especially within the knowledge of any person, the burden of proving that fact is upon him.
Lordship, I have tried to discharge that burden by giving 4 BPL cards and the 5th APL card that I had in my possession.
You are just proving nobody is disputing that there is entry at least in the that register of the distributor, and also 4 BPL card. And so far as APL card is concerned, distributor register entry is there, which is not there in the APL card, right?
Lordship.
What you say, what is your stand? Your stand is that you have been entrusted by these 5 persons. Otherwise, how will you receive them? So you are entrusted by 5 persons, and on their behalf you have received the rice, and you are taking it for them. That is exactly your plea. Now, for that, if you take that plea, then the burden shifts to you to prove, not the prosecution to prove them to disown their aid. So question is that how much, in what type of case, what should be the, suppose let us say another example I am giving. The husband and wife, they were sleeping in a room in the night. In the morning, the dead body of the wife was found with bleeding injuries, and the husband was absconding. Okay. So ornaments were also missing, of the wives were also missing. So when both of you are there in that particular room in the night, in the morning it happened. If it is your case that no, I have not killed my wife, somebody else came and they tried to rob my wife protested, I also protested, and in that process the murder was done. So that is within your special knowledge. So you are required to prove it.
Discharge that burden.
Okay. Prosecution will simply prove that both of you were together in that room in the night. In the morning, the dead body was found in bleeding condition and it was a homicidal death. Rest of the things shifts to you. Similarly, here in this case, the prosecution has proved that from your possession, 100 quintals of 1 quintal, I'm sorry, 1 quintal of rice was seized in 5 bags. Each bag was containing 20 quintal and 20 kg, I'm sorry, 20 kg. And simultaneously from your possession also 5 cards were recovered. So if those 5 persons entrusted you to receive the rice on your behalf, it's well and good. You could have examined them to prove that yes, they have entrusted you.
That I have not done, Your Lordship.
If they had in fact entrusted you and you are doing good to them, they will definitely come forward to say that yes, what is there? We have sent it because we have this difficulty. We handed over ration card to receive the rice on our behalf. So how it will be found that whatever you have received or what has been disbursed to you was genuine one, or in fact you have, because you are not proving the authorization, you are not examining those persons. One of the cards also the entry is missing. So that is how it comes that you are illegally possessing it, and it may be to misappropriate that 100 quintals of rice. That was the reason.
Lordship, the authorization as per the villagers to give to the present appellant, that Your Lordship, it is.
I am also ignoring that part also.
Lordship.
Let us say that I am ignoring that villagers and if there is no such procedure like in postal department. Suppose somebody is having a passbook, he sends Mr. X. We are also doing that. We are also sending checks to with our PSO to receive the amount. So the question is that when we are sending our passbook for withdrawal of the money, so we must authorize that this is the signature we must attest, and the person concerned in whose favor that money is to be handed over, his signature should be there, and that particular document he should verify that yes, this person has come with this particular document of authorization, and whether I am taking the person's signature and identity proof, whether it is matching with him or not. Then can only money will be disbursed to you. Otherwise, postal will also not.
In today's time, Your Lordship, without authorization,
it is not. So that is how you are taking 5 cards with you and receiving the rice, and those persons are not coming forward to say that they have authorized you to receive the rice.
Lordship, may kindly see deposition of DW1 at page 58.
No, you finish it. Then we'll go to that.
Hence, it is clear that accused Manoj Kumar.
Where are you reading?
Lordship, page 21, 9 lines from the bottom. Hence, it is clear that accused Manoj Kumar Mahanti had misappropriated 20 kgs of rice of one Gangadhar Sethi, to which he had not entered in his APL card, but had entered in the sale register on 1999. Further, from the evidence of PW2, it is found that in card number such and such, all 4 cards have been mentioned, Your Lordship. Accused Manoj Kumar Mahanti had given 80 kg of rice to accused Narendra Sethi on such date. Though the above noted persons have not come to take their BPL rice from accused Manoj Kumar Mahanti, so it is clear that accused Narendra Sethi had brought the cards of the above noted persons and received 80 kg of rice from accused Manoj Kumar Mahanti with convenience, and while he was transporting, he was detained by the villagers. PW3 had stated that on 1999, he had been to bring rice from the sale center of accused Manoj Kumar Mahanti. The said villagers had also been to bring BPL rice from the accused Manoj Kumar Mohanty. Accused Narendra Sethi took 1 quintal of rice from accused Manoj Kumar Mohanty. Accused Narendra Sethi took the rice in 4 consumer carts, and then he and others told the secretary why he had given 1 quintal of rice to accused Narendra Sethi in 4 carts. In reply, accused Manoj Kumar Mohanty had told them that by mistake he had given the rice to accused Narendra Kumar Sethi. We'll examine that particular witness, Your Lordship. He himself, one Mohan and others detained 1 quintal of rice from the possession of the accused Narendra Sethi, and then he informed the matter to the marketing inspector. The marketing inspector seized the rice in his presence and also the cycle and consumer cards, which was in the name of Gangadhar Sethi. The MI prepared the seizure list while Exhibit 2 and Exhibit 2 by 2 is his signature. Exhibit 2 by 3 is the signature of accused Narendra Sethi. As he was acquainted with the handwriting and signature of accused Narendra Sethi, he proved the same. In cross-examination, he has stated that accused Narendra Sethi took 1 quintal of rice in consumer carts of himself, Subhasini Sethi, Gangadhar Sethi and Siba Sethi. Accused Manoj Kumar Mohanty had issued the rice in 4 number of BPL card and 1 APL card to accused Narendra Sethi. Accused Narendra Sethi had received 1 quintal of rice in consumer card such and such, such and such. From his evidence, it is clear that accused Manoj Mohanty had given 1 quintal of rice in the above APL and BPL cards to the accused Narendra Sethi. His evidence has not been shaken by the learned counsel for the defense, and his evidence finds full corroboration to the evidence of PW 2 and 4, who was the ABDO of Bisoi block, has stated that on 1999, accused Manoj Kumar Mohanty was dealing with the APL and BPL rice of Bisoi Grama Panchayat, and the sales center was situated at Bisoi Market Campus. At the instance of the chairman of the block, he went to the market complex and found 200 to 300 consumers were gathering near the sales center to purchase rice. The public told him that they had detained accused Narendra Sethi as he was illegally carrying 1 quintal of rice in his cycle by taking the rice from accused Manoj Kumar Mohanty. Thereafter, he called the marketing inspector and the nodal officer to the spot. He himself and the MI and the nodal officer checked the sale registers of accused Manoj Kumar Mohanty, and they found accused Manoj Kumar Mohanty had given 1 quintal of rice to accused Narendra Sethi in 5 consumer cards. And thereafter, the marketing inspector seized the sale register from accused Manoj Kumar Mohanty, while Exhibit 1 by 2 is his signature. In cross-examination, he has stated that he was not dealing with APL and BPL rice of Panchayat Secretary. He has no direct knowledge about the distribution of rice of the consumers. He had not verified the stock of rice. Accused Narendra Sethi had taken 1 quintal of rice from accused Manoj Kumar Mohanty of his villagers for better movement of rice and for betterment of the consumers. There is no provision to take rice of 5 consumers by 1 person. However, from his evidence, it is clear that accused Narendra Sethi was taking 1 quintal of rice in 5 consumer carts of 5 consumers from accused Manoj Kumar Mohanty. Clearly, PW4 has stated that 1 person cannot take 1 quintal of rice of 5 consumer card holders. They have not mentioned any law that prohibits it. So this evidence has been sufficiently proved to the evidence of PW2 and 3. In course of argument, the learned counsel for the defense contended that the license of accused Manoj Kumar Mohanty has not been proved by the prosecution. For that, the accused has not contravened any clause of 3(1) of EC Act and clause 8 of Odisha Paddy and Rice Control Order 1965. Section 3(1) of Odisha Rice and Paddy Control Order 1965 states that no person shall act as a dealer except order and in accordance with a license issued in that behalf by the licensing authority, provided that the government may, by a special or general order, subject to such conditions as may be specified in the order, any class of person from the operation of this subclause. So it is clear that without any license from the competent authority, a person cannot be the dealer. In this instant case, the accused Manoj Kumar Mohanty was the Grama Panchayat Secretary of Bisoi GP, and he was dealing with the APL and BPL rice. He was also giving the APL and BPL rice to the ration card holders. To the effect, the marketing inspector was supervising authority of the APL and BPL rice. PW2 has clearly stated that he seized the sale register in 2 volumes from the possession of accused Manoj Kumar Mohanty and prepared the seizure list. Exhibit 1 of the sale registers and Exhibit 2 is the seizure list of APL rice of accused Narendra Sethi. Apart from that, under section 313 CRPC, accused Narendra Sethi has stated that he had taken 1 quintal of BPL rice from accused Manoj Kumar Mohanty, the secretary of Bisoi GP. Hence, it is clear that the accused had received 1 quintal of rice from the accused Manoj Kumar Mohanty by 4 number of APL and BPL cards. Lordship, there is a confusion regarding 4 and 5 in the ration cards, Your Lordship. I am placing, hence it is clear that the accused had received 1 quintal of rice from the accused Manoj Kumar Mohanty by 4 number of APL and BPL cards.
No, it may be that is actually 4 BPL and 1 APL.
Yes, it is wrongly.
It's wrongly done, typographical. Yes.
So also it is clear that accused Manoj Kumar Mohanty was dealing with APL and BPL rice for consumers in Bisoi Grama Panchayat. Apart from that, accused Manoj Kumar Mohanty has admitted under section 313 CRPC statement that accused Narendra Sethi had taken 1 quintal of rice from him for 5 number of BPL card holders of the Grama Panchayat. However, both the accused persons have admitted their guilty. PW 3 and 4 have stated that while accused Narendra Sethi was carrying 1 quintal of rice by his cycle, at that time they and other villagers detained him, and thereafter at the instance of the villagers, the marketing inspector, that is PW2, seized the rice along with cycle in question from him. PW2 has clearly stated that the card bearing number such and such of Rabindra Sethi, such and such of Shiba Sethi, such and such of Subhasini Sethi, and such of Nagendra Sethi have been seized by him. Narendra Sethi have been seized by him, and accused Manoj Kumar Mohanty had entered this sale in his sale register without entering in the APL and BPL cards. Here they are stating it is not entered in both the cards, Your Lordship. Wide APL card number such and such of Gangadhar Sethi. Accused had not entered in the said APL card regarding issue of rice, but has entered the said issue of rice in the sale register.
Okay, you come to paragraph 9, that DW1.
DW1 has stated that his village is at a distance of 15 kilometers from Bisoi, and there is no route communication from his village to Bisoi. On 1999, he had been to Bisoi to bring his BPL rice from the Grama Panchayat. Narendra Sethi, Shiba Sethi, Subhasini Sethi, Rabi Sethi, and Naren Sethi had been to Bisoi to take BPL rice. After bringing the rice from accused Manoj Kumar Mohanty, they all kept their rice in one bag and stitched the bag. He loaded the bag in the cycle of Narendra Sethi, and at that time, all the above BPL consumer card holders were present. In the meantime, marketing inspector came and detained the bag. So it is clear that accused Narendra Sethi was carrying 1 quintal of rice of Shiba Sethi, Subhasini Sethi, Rabi Sethi, Narendra Sethi, and Naran, but none of the above cardholders have been examined on behalf of the defense. It was the duty of the defense to bring all the above consumers to examine in the court to substantiate their plea. If they might have been examined, definitely I would have come to a conclusion that on such and such date, the above named consumer card holders had taken rice from accused Manoj Kumar Mohanty individually. So the accused persons have created a plan by saying that the above consumer card holders had come to take the rice from accused Manoj Kumar Mohanty on such date. So it is difficult on my part to believe the evidence of DW1. PW 5, 6 and 7 have invested into the case. PW 5 has stated that on 20th October 99, he took charge of the case and left the seized rice in Zimma of Marketing Inspector Bisoi. After receiving the order from Collector Mayurbhanj, he had seized the tally register on production by accused Manoj Kumar Mohanty at the police station, White Exhibit 16. PW6 had stated that on 1/6/99 he was the OIC of Bisoi PS and had registered the case. On 11 September 99, he seized the BPL card bearing number such and such on production by accused Narendra Sethi, White Exhibit 17. He left the seized BPL cards in Zimma of the accused Narendra Sethi, White Exhibit 18. So from the evidence of PW6, it is clear that he had seized the consumer cards on production by accused Narendra Sethi. If at all the consumer card holders had come personal to take the rice, then why accused Narendra Sethi had kept the consumer cards with him? Generally, the card holder should keep each of their cards with him. That is not the case, Your Lordship. When while transporting, the person who's transporting the said rice, they keep all the cards with them to show proof. So I think accused Narendra Sethi had collected the consumer cards from the consumers of his village, and with convenience of the secretary Manoj Kumar Mohanty, he had received 1 quintal of rice with malafide intention. PW7 has stated that on 1999 at the direction of the OIC, he investigated into the case. He seized one old bicycle, 1 quintal of controlled BPL rice with a gunny bag loaded on a Hero Royal bicycle bearing number such and such, one APL card number such and such in the name of Gangadhar Sethi, sale registers from 21/12/98 to 9/7/99 containing 27 pages, etc. Further, he stated that on 7/7/99, the GP secretary had issued 20 kgs of rice in one APL card, and the same card issued further 20 kgs of rice illegally. However, PW 5, 6, and 7 have properly investigated into the case. So, from the above discussion and observation, I come to the conclusion that prosecution has sufficiently proved his case against the accused persons beyond all reasonable doubt, as accused Manoj Kumar Mohanty had sold 1 quintal of rice illegally to accused Narendra Sethi, and accused Narendra Sethi had received the said rice in question at a time from accused Manoj Kumar Mohanty with a malafide intention. So
now come to the accused statement, page number 38. That is of Manoj Kumar Mohanty. Page 38, question number 4.
PW3. Chandra Mahaput says that you were the GP secretary of Bisoi and authorized to sell APL and BPL rice. On 1999, he had been to your sales center to bring rice along with other villagers at rupees 2 per kg and found that accused Narendra Sethi took rice in 4 consumer carts. And he and others told you why you had given 1 quintal of rice to accused Narendra Sethi in 4 carts, and they detained 1 quintal of rice from the possession of accused Narendra Sethi. Actually, may I clarify at this point? They have put this question that he has taken in 4 cards because in the APL card there was no entry. They are only calculating those cards in which there was the entry. That is why they have put this question. And they detained 1 quintal of rice from the possession of accused Narendra Sethi and informed to the marketing inspector Bisoi Block, who seized the same in his presence. What have you got to say?
ପାଞ୍ଚ ଜଣ ଲୋକଙ୍କର ବିପିଏଲ କାର୍ଡରେ ମୁଦାଲା ନରେନ୍ଦ୍ର ମୋ ଠାରୁ କଣ୍ଟ୍ରୋଲ ଚାଉଳ ନେଲା
1 क्विंटल
1 क्विंटल
1 क्विंटल चाउଳ
Admittedly, Your Lordship, the villagers who had given him the consumer cards, they are staying at a distance of 15 kilometers from the said place. Apart from that, he was carrying all 5 consumer cards. In case a person or a villager does not get the ration for the entire month, there is a possibility, there is a much sure possibility that they would come and find out what has happened to their share of the rice. That fact, although I have submitted the ration cards, I have not examined the persons who were holders of the said ration cards. At the instance when I was caught with the rice, all proof that I had was all those cards that I have submitted before the police, before the prosecution. But the fact that I had a malafide intention in procuring those 100 kgs of rice for myself or for sale at any other marketplace, that also has not been established by the prosecution. Although there's a lacuna in my case, I did not examine them as DW1. This case, there wouldn't have been a case at all. But is that malafide intention on which I've been convicted, that mens rea, does it exist only because I was in possession of those 1 quintal of rice supported by all 5 ration cards? Also, if I had not entered the said APL rice in my register and also the APL card, then also a case would have come up where I've tried to illegally take 20 kgs of rice in connivance with the said Manoj Kumar Mohanty. But the fact that the said was entered in the register by mistakenly or for any other reason.
Mr. Any witness has stated as to about the procedure of disbursement of BPL rice in absence of that particular person in whose name that ration card is, it doesn't come for us.
That is what the trial court has held,
that PW2 and 3, they have categorically stated that there is no such provision that
देखिए PW2 कौन 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 हाथ तो लिखा हो रहा को
one cannot take 5 persons ration at a time.
Actually, there are instances where people are handicapped. They are old age
So,
people living in villages.
No,
are you having a copy of that PW2's evidence?
Page 44, Your Lordship, but it is
very difficult to read.
On 1/9/99, I was MI at Bisui. On that day, my Lordship has it, please.
Yes.
On that day,
No, it's all right. Our next line is, I found the villagers of so-and-so kept one person,
kept
one quintal of rice by
from Narendra
from
Sethi with me.
And Narendra had brought the 1 quintal from so-and-so.
Narendra Sethi did not produce, in which he only showed the rice.
पूरा entire deposition of हाथ लग दी.
Besides that, my lord, even if it is
this is the marketing inspector, Your Lordship, who has to prove
from the other side is that it was the persons who were requested the appellant number 2 to bring the rice from appellant number 1, and where there is the entrustment, and why the defense did not choose to examine them as DW. At least they could have come to the court and say that yes, we are actually the persons entrusted the appellant number 2 to bring the rice on our behalf.
Although I have not discharged the burden of proof completely, Your Lordship, but I have at least submitted the ration cards of the 5 persons. The prosecution could have.
Apna you Babu Narendra Sethi. Narendra Manoj Sethi hochi distributor.
Manoj Kumar Mahanti.
Manoj Kumar Mahanti. ये जो नरेंद्र सेठी होची दी अदर पर्सन फ्रॉम होम सीए तार आक्यू स्टेटमेंट देखुन कोठी कहिछि जे मते 5 जण कार्ड देकिनी पठेइथिले जाइकिनी आठू धान चाउल रिसीव करिया पई.
No,
that accused statement is there. It starts in page number 40. Read each question and answer given. Court is a कहिछि जे मते 5 जण एई लोक पठेइथिले एवं मते देइथिले मध्य कार्ड देइथिले कहले जाइकिन तू आकोठू मनोज महांती कोठू जाइकिन आम तरफु येटा नै आसी आनिकिन हमहु दब.
Rather, my lord, in question number 9, he has said that ଆମ ଗାଁ ଲୋକ ମୋ ବିରୋଧୀ ହୋଇଥିବାରୁ ମିଛରେ ମନରେ କହିଛି.
Those are the persons who have been examined as prosecution witness. That is what he's talking.
No, that's a different matter. Where is your plea?
Not sure.
अरे आपण plea ही नहीं ना दी. What about the proving your defense plea? आपण खाली कहले मो गां लोक मोर विरोधी होइतिबारु मते आनिकिनी मिछर केस पकई जांदी. आपनकर अबिका जोटा आर्गुमेंट नौचंती जे 5टा लोक मते देइथिले कार्ड एवं से तांकरी चाउल मु रिसीव करी तांका पाकू नेकी जाउथिलु. तो ये कोडी आपण अच्छा ये जो क्वेश्चन टा क्वेश्चन नंबर 4 को आसिले पेज 41 रे क्वेश्चन टा पढो तो आंसर टा देखो.
Question number
4 पेज नंबर 41.
PW3 Chandra Mahakut says that on 1/9/99 he had been to the sales center of APL and BPL rice to bring rice along with other villagers at rupees 2 per kg and found that you took 1 quintal of rice in 4 consumer carts and they told you that why you had taken 1 quintal of rice from co-accused Manoj Mahanti and they detained you, rice and the cycle which PWT seized at the spot. The police arrested you and being produced by PW2 and others. What do you have to say? He has stated that Mudala Monostu Eco Quintal Chawla Neij. He has stated to the suggestion that was put that he had been to the sales center of APL and BPL rice to bring rice along with other villages.
ନେଇଛି କହୁଛି ନା ନେଇ କହୁଛି ନେଇଛି ये जो आर रेजिस्टर टा केते एग्जिबिट ହେଇଛି जो मनोज महांती पाखर जो
Exhibit 6 is the sale register.
डेट ऑफ occurrence केवे
1/9/99. Also, Your Lordship, from PW.
1999
Okay,
are you sure it is 19
Lordship.
1999 at about 1 p.m.
99 तो किसी एंट्री ही नहीं is a PCR to जो ECR to पूर्ण
Central government.
अंडा मगा नहीं कौन कोई दिवस अभी कर दीपू एबेकार ना पुराना दरकार जो अमेंडमेंट करी कही थी वो
अच्छा दियो जो था
1999
Now, my lord, Exhibit 6, my lord, where the plea is being taken that Exhibit 6 is the cell registered, my lord, by that Manoj Kumar Mahanti. That was the APL card, issuance of rice APL card was entered. That is dated 7/7/99.
नहीं एपीएल कार्ड पूरा एंट्री है ही नहीं ଏଥର ତାଙ୍କ କେସ୍ ହିଁ ସେଇଆ ବିପିଏଲ କାର୍ଡ ଗୁଡାକରେ ଏଣ୍ଟ୍ରି ହେଇଛି
APL card ଯୋଉଟା ସେଟା 2 ମାସ ପୂର୍ବରୁ
ଓହୋ ସେଦିନ ପୁରା ଏଣ୍ଟ୍ରି ହେଇନି ସେ କହିନାହାନ୍ତି ସେ ଦ୍ୟାଟ୍ ଇଜ ଅଲସୋ ୱାନ୍ ଅଫ ଦି ରିଜନ ଏଇ ଯୋଉ ଗୁଡାକ ରହିଛି ଆମର ଲେଟେଷ୍ଟ ସେ ପୁରା କେତେ ଏକ୍ଜିବିଟ ମାର୍କ ହେଇ ଜଣା ପଡୁନି ଏକ୍ଜିବିଟ 5 ଏ 1999 ରେ ସେ କାର୍ଡ ଗୁଡାକ ମାର୍କ ହେଇଛି ଏକ୍ଜିବିଟ କହିଲେ
card recommended Exhibit 9
use the microphone
Exhibit 9 madam.
yes ଗୋଟିଏ ମାତ୍ର
Repel Exhibit 10 another of Shiva Sethi. Exhibit 9 is Ravindra Sethi. Exhibit 11 my lord Subhashini Sethi. Exhibit 12 that is of Narendra Sethi.
yes ଚାରଟା ହେଲା ଆଉ ଏପିଏଲ ଟା
exhibit 5 your lordship
Exhibit 5 no.
of Gangadhar Sethi.
So, Mr. Mishra, suppose सेल रजिस्टर एंट्री हला माने यार जो महांतीर
ଆଜ୍ଞା
डिस्ट्रीब्यूटर
ଆଜ୍ଞା
ये लोकटा पाखरु मिलिला 5टा अलगा अलगा बंडल रही एवं या पाखरे जो 5टा कार्ड मिलिला तदरु बीपीएल कार्ड रो जो एंट्री हिच देख सरलेनी बीपीएल कार्ड रे 1/9/19 रे रही एपीएल कार्ड टा एंट्री हिच वर्तमान होची तो आर प्ली
बीपीएल
होची
जो एंट्री ହେଇଛି बीपीएल कार्ड रो सेटा एंट्री ହେଇଛି सेल रजिस्टर रे
हां
ना ना
सेल रजिस्टर
नहीं ना कार्ड भी सीज ହେଇଛି प्लस जो रजिस्टर भी सीज ହେଇଛି सेटा कोरोबोरेट करूची
Lordship is seeing from the BPL card.
मु एटी एग्जिबिट देखुची परा मु बीपीएल कार्ड देखुची जोटा की मार्क ହେଇଛି आपनकर एग्जिबिट हिसाब रे एवं आदरे एंट्री अछि मध्य 1/9/19 रे राइस 20 केजी एवं सेटा सीज ହେଇଛି 12/9/1999 मसिया रे हला एवं
सीज ହେଇଛି 12th of September में 12/9 को सीज ହେଇଛି
12/9/99 डेट मध्य अछि सिग्नेचर 12/9/19 रो
but the incident is of 1st of September.
पीएस केस नंबर पड़ची latter point of time रे जब थेछि whatever it may be so what I suppose let us say से रजिस्टर जो महांती रो डिस्ट्रीब्यूटर रो तादरे एंट्री तादर देखो जे ई 5 जन को एथि केथि दिया है जो 5टा कार्ड भितर 4टा कार्ड रे इश्यू हेची जो ए लोक मानु दिया है 20 के सेटा ता सारे मैच कोछ किंतु आउ गोटे जो एपीएल कार्डटा जदियो सेठी मेंशन हेची महांती रो रजिस्टर रे मेंशन हेची जे भी दिया हला किंतु यारो जो एठी नाही माने एपीएल कार्ड रे एंट्री नाही वर्तमान होची तारो आपणकर जदि ता प्लीटा होची जदि ए 5 जन ताकू इंटरेस्ट करथिले आनिबा पई से प्रकार प्ली आपण नै नाथि सी द डिफिकल्टी गेट रेडी आपण 5 जन आपण को इंटरेस्ट करथिले ए प्ली आपणकर एक्यू स्टेटमेंट रे ही नाही
Lordship, that question 4 my lordship put that of the accused statement.
हम पर आपन एक्यू स्टेटमेंट देखैली देखो ना दी कोठी अछि
Okay.
आपन को एक्यू स्टेटमेंट ए बाटलो से
Let me please. Page 41 your lordship.
I am accused statement of Narendra Sethi. She is the main witness.
Question
question number कोटा कहउजन
4 of page 41. PW3 चंद्रमा को
सेटा कुहाउची जे सिए कहला मु मनोज ठारू 1 क्विंटल चाउल नेइछि एया ही आंसर देइछि क्वेश्चन नंबर 4 आंसर टा देखुना दी
आगे
हां मु कोन मनोज ठारू 1 क्विंटल चाउल नेइछि
हां मु मुदला मनोज टू 1 मुदला
अच्छा हां हैला ठीक है
मनोज को टू 1 क्विंटल चाउल नेइछि
एई जो स्टेटमेंट टा जो आपण कहिले सेटा तो प्रोसिक्यूशन केस ही होछि आपण ताडू नै छथि आपणकर प्लीटा कोन होछि मु 5 जनकर
my response is as per the question number 4 your lordship. Question number 4 says that he had been to the sales center of APL and BPL rice to bring rice along with other villagers at rupees 2 per kg and found that you took whatever that amount has been mentioned after that. But along with the other villagers is the suggestion put to me for which I've replied, हाँ मुझे 1 क्विंटल चावल मनोज कोठू नहीं
सीटा की कहूना दी डिस्ट्रीब्यूट माने क्वेश्चन होची जो ए जो चावलटा आपण नेले सेटा 5 जनक पाई नेले जोटा की बर्तन आपण 5टा कार्ड धरिकिन कहउछन्ती से प्ली काई आपनकर
Along with other villagers in 4 consumer cards. That is the question put to me. Chandra Mahakut says that on 1/9/99 he had been to the sales center of APL rice to bring rice with other villagers and found that you took 1 quintal of rice in 4 consumer cards. Persons have
अरे
not.
आपनकर एटी आंसर दबार थिला मते सेही 4 जण बा 5 जण मते कंज्यूमर मते देइथिले कार्ड एवं मु रिसीव कली आपन प्ली होची आपन ता ऑन बिहाफ ऑफ दोज 5 पर्सन्स यू रिसीव इट किंतु आपन 5टा कार्ड रे रिसीव करनी चंदी 4टा कार्ड रे आपन रिसीव कर दी चंदी गोटे क्विंटल किंतु सेमानक पाई रिसीव कले बेली प्ली नोना
persons को behalf रे that
हां
suggestion
सेही जिंसडा नहीं ना प्ली क्वेश्चन होजी सेया इफ यू वुड हैव टेकन दैट प्ली कारण आपनकर लाकुना केते रहिछि देखो से 5 जण को एग्जामिन कलेनी से प्ली भी नेलेनी जे आपण से 5 जण को ये को
Not
एवं
even suggestions to other witnesses, my lord.
हाँ ए जो
DW1
Cross-examination.
जो माने सीजर विटनेस
My lord.
सीजर
witness
तो आपण
not
एडमिट
present.
करछन ना सीजर फ्रॉम योर पोजीशन
100
जो
kg of
साक्षी
rice I'm not disputing.
नॉट डिस्प्यूट तेणु आपणकर तांकू सजेशन दबार कोन थिला जे जो राइस ठीक अछि राइस रा एटा से 5 जण लोक रामदाम साम जो मानकर कार्ड जब थला सेही माने ही मते ये करथिले तांकू मध्ये सजेशन दबार थिला हां
Actually, I may not have introduced them, the other persons, consumers, jaha behalf.
You are saying that the prosecution should have examined them
when I have
nullify.
When I have produced a positive evidence in my regard, that is the production of the ration cards, which has been seized. There's entry in the ration card. There's entry in the register. Plus DW1 is also not supporting.
No, you are producing the not your card. You are producing the card of XYZ.
Lordship may consider a case. Lordship may consider a case where I did not have the ration cards on me. I had only 100 kgs of rice on me. That is a case where if there is an entry in the register in the absence of the cards, there is some
it's a people's right. If you suppose you steal it from them and take the rice, then what will happen? Question is that whatever you take the plea, there must be material to support your plea. It is not required that you are required to prove your case beyond all reasonable doubt. But preponderance of probabilities factor जोठी कि आपनकर स्पेशल नॉलेज अछि सेठी आपनको शिफ्ट ही जाउछि जेमती आपनकर लेट अस से प्ली ऑफ आलिबी आपण गोटे मर्डर ହେଇछि आपन चार्ज हला जे आपण ए मर्डरटा करछेंदी you are saying that no I was not at that spot on that day I was at Koraput and in my office in my company I was there so the burden shifts to you because it is within your special knowledge so you are to examine some persons from your company some document from the company to show that yes no this particular time he was doing a shift in the company so
what I have merely is just the bus ticket that I have gone there but not any other eyewitness who has seen me who has to prove my alibi.
So something
I may not have completed the entire link of evidence
that is required to be proved in a case of this nature that standard of proof is not a preponderance of probability that standard is like beyond all reasonable doubt because it shifts to you plea of alibi your standard of proof like the prosecution case proving it beyond all reasonable doubt because it is within your special knowledge you are taking that plea so similarly here you are taking a particular plea you are not taking that plea that 5 persons has entrusted you that plea has not taken let us say that even otherwise we will say that suppose 5 persons have entrusted you that for that whatever entry is there that you have just proved but not the other things.
Lordship, now if there are 5 cards in my possession, I am stating that these 5 people have entrusted their card to me.
You have not taken that plea. Where have you taken? That is the question I'm asking you repeatedly from the beginning. Look at your accused statement. Look at the suggestion given to any witness.
That has been developed.
That is also Mr. Mishra is pointing out. That have you taken a plea? Have you suggested to any witness that you are carrying that on behalf of 5 persons?
That has been reflected in the
Assume gote court assume kari paribani ei jinso re. Eta circumstantial evidence ro gote jo power achi je that's a different matter, but that the circumstances cannot be explained under any other hypothesis. So that's a different matter. But here is a clinching circumstance against you. Here is a clinching thing that it was recovered from you. You are found in possession of 100 quintals of BPL and APL rice. 4 cards you are there. 1 card is there in which no entry is there. Those 4-5 persons are not coming forward to say that they have entrusted you to bring the rice on their behalf. No authorization is there, and you are not also taking that plea either in your accused statement nor giving any suggestion to any of the witness that yes, I have received it. It was seized from my possession, but that was for these 5 persons. In that situation, how can you say that you have discharged your burden? Now you we have opened you. Now you analyze it in detail for the evidence, if anything is there, and also analyze this provision that in such a circumstance, when it was within your special knowledge, then that you are taking that plea, then it is your duty to prove that plea. It's not that is the language of section 106. କାରଣ prosecution ଯେତିକି discharge କରିବା କଥା, initial burden they have discharged in the sense that 100 quintals of rice was seized and 5 cards were also seized. Out of 5 cards, in 4 there are entries. In 1 card there is no entry. These are all facts, and you are not disputing also the seizure aspects. These are facts. Question is that how you receive it, who has entrusted you. If they have entrusted you to receive, there is there is evidence to that effect. Obviously, you are not misappropriating those rice. That would not be there. But if there is no such evidence and you do not prove this fact, which is especially within your knowledge, and burden of proving that fact lies on you, then it can be said that you have not discharged it.
You may consider a situation where I have not discharged the burden of proof, supposedly. Now,
prepare thoroughly, come to the next week. Hard in part, list this matter. Don't make hypothetical argument. List this matter on 17th of August 2023. Hala? Top any issue. Yes, anyone is ready? Yes. No, that you have to make a submission in presence of the Vigilance Council, and they should also be handed over the paper book if it is available with them, and they should also be asked to get ready so that because we are taking the matter serially one by one. If any matter which is not there down below, then they are to be given earlier intimation. Today also, Vigilance Council was there and he was asked to prepare a case. I think Mr. Mahapatra's case was there. Next week, you make a mention in their presence and just previously ask them that whether they have received the paper book or not, and tell them that you are going to mention this matter, so that let one of them remain present, and in their presence, if the date is fixed, today also we fix the date to one matter in September also fixed on Thursday, right? Okay.